Do it. All right, good morning down in Osceola. Can you hear us?
Yes, Your Honor. Good morning.
Good morning. Who is down there for, who's the defense and who is the state?
Donald Carbone from the Public Defender's Office for the defense.
Jonathan Marino, pretrial release.
Thank you. All righty, we'll try and get, I apologize for the delay. We're running a little late today on things. Let me know if any of these need an interpreter, please. First one I have is German Cologne Mendez.
Yes, he's a Spanish interpreter. Your Honor, can we have call 2 first, self-harm pursuant the jail's requesting?
Which ones?
Anthony Mendez.
Okay, hold on a minute.
I'd like to waive the reading of the charges.
Hold on a minute. Mendez, he said, I'm trying to.
Anthony, not Andy.
Yeah, I saw there was 2 of them. Anthony has 2 cases. Yes, sir. And where is he?
He's approaching. He's in the box.
Okay. He is approaching, or is he back in the back?
He's in the back. Here he comes.
Okay. Yeah.
I'd like to waive the reading of the charges.
Okay, he has 2 different charges. Are you talking about both of these? One's a violation of probation community control, the other are the 2 substantive charges?
Yes, Your Honor.
Okay, I have reviewed the charging affidavits. I did not need to. There was a warrant issued in this matter signed by the judge setting bonds on count 1, which is the negligent manslaughter at $5,000. Count 2 is the possession of a weapon. Yes. At $500.
Okay.
Yes, sir. And public defender has been appointed to represent him?
Yes.
And you're also representing him on the violation of probation?
Yes, Your Honor.
Is there anything else you wish to address with the court in this matter?
No, Your Honor.
Okay, not guilty, pleas rendered. Probation's none. All right, thank you. Who was the other one you wanted to call up?
Helena Thompkins.
Tompkins?
Elena Thompkins.
Okay. Last name is
She's in the box.
Tompkins?
You just have to-
I'm sorry, is the last name Tompkins?
Yes, Your Honor.
I believe she's
Helena,
a,
not Daniel.
yeah, I think she's a co-defendant. Elena Thompkins, she is a co-defendant to Daniel Tompkins, I believe. Is she there with you?
Yes, Your Honor.
All right, ma'am, you want to come over to the microphone, or are you at the microphone? That's good. Tell me your name. Ma'am?
Elena Thompkins.
Thank you.
Hi.
How are you? You have a charge of aggravated assault with a deadly weapon. I have reviewed the charging affidavit. There is probable cause in this matter. You also...
Your Honor, we'd ask for her to be.
Go ahead.
We'd ask for her to be. We asked for her to be ROR'd pursuant to the jail and the mental health medical segment. She's going to be Baker acted. I don't believe she has any criminal history as well.
Okay. Oh, is this it?
Yeah.
Okay, let me look at this for a second. This is coming from the pretrial.
Yes.
State, are you familiar with this case?
Takir Watson on behalf of the state.
You're asking her to be released on pretrial release? Is that correct, counsel?
Well, ROR, but in lieu of that, we would ask for pretrial release.
Well, she doesn't even qualify apparently for pretrial release in this matter.
Yes, Your Honor, that's what the state would be arguing.
I'm going to leave the bond where it is. I think for right now, she's going to be, if you want to have a full hearing in front of a judge on it, but based on the limited information that I have, the bond is an appropriate amount, and I'm going to deny a request on any release of any manner other than on bonding out in this case. She is to have no contact with the victims, and she is to have no contact with the co-defendant. Is that all of the move-ups you need to take care of?
Yes, Your Honor.
All right, public defender's appointed in that, it's not official already. All right, let's see if we can get back on our docket. Okay, now what did I do with my first case though? I just got it out of German,
Sorry, what was the bond on that last one, Your Honor?
3,000.
Thank you.
German Cologne Mendez. Does he need?
Yes, he's a Spanish interpreter case.
Okay, we have our interpreter.
Yes, Your Honor. The Spanish interpreter is on the line.
Thank you. And you've already been sworn?
Yes, Your Honor. From
Thank
this
you.
morning.
Yep, I think I remember that. Okay. Sir, good morning. Tell me your name.
Buenos días, señor. Dígame su nombre.
Germán Colón Méndez. Colón Méndez,
Colón.
Germán.
Herman Colón Mendez.
Okay. Sir, do you speak any English?
¿Habla inglés, señor?
No speak in English. No, español. Y no muy bien.
Spanish and not very well.
Okay. Well, you speak more Spanish than I speak more English than I speak Spanish, I can assure you.
Bueno, le aseguro que usted capaz entienda más el inglés que lo que yo entiendo el español.
We have an interpreter here for us today to interpret from English to Spanish and Spanish to English.
Tenemos un intérprete quien interpretará todo de inglés a español y de español a inglés.
You have a charge of possession of cocaine
Tiene una acusación de tenencia de cocaína
and possession of drug paraphernalia.
y tenencia de artículos de droga.
I have reviewed the charging affidavit.
He estudiado la affidavit de arresto.
There is probable
Your Honor,
cause.
this,
Yes, sir.
I'm sorry.
Yes, sir.
Yes, this defendant, he's found incompetent in 17 MM 3242. So we'd ask for him to be released on his own recognizance or mental health with PTR with mental health conditions.
I missed the first part. Let me finish with the present charge that we have, and then I'll deal with the existing charge. There is.
Su señoría, I'm sorry, Your Honor. Su señoría, el fallado no competente en el caso 19 MM3242, por eso quisiéramos pedir que quede en libertad bajo palabra o en libertad provisional con condiciones psicológicas. Déjeme terminar primero con el caso y después continuaremos.
The court is inclined to impose a bond of $2,500 on the possession of cocaine, $150 on the possession of the drug equipment possession and use in this matter. He does have and was out on bond apparently on another case involving also a cannabis issue in this matter. What did you want to be heard on, sir, about this?
El juzgado está dispuesto a imponer una fianza de $2,500 en el cargo de cocaína y de $150 en el cargo de artículos de droga. También hay un caso que tiene que ver con el uso o con la presencia de cannabis. ¿Qué desea decir, señor?
Yes, sir.
In 17 MM 3242, he was found incompetent, so we'd ask for him to be placed on conditional release.
En el caso 17 MM3242, él fue hallado incompetente, pues, por eso quisiéramos pedir que a él se le otorgue la libertad provisional.
I have a note that he has a pending competency hearing on the 24th of February, not that he's been found incompetent. Am I
Yo tengo
incorrect?
acá en mis archivos que él tiene una audiencia vigente en el futuro para que se determine si es incompetente o no, pero no que ha sido determinado incompetente todavía, ¿correcto?
Yes, Your Honor, but on 6/21, 2018, he was found incompetent by Heather O'Brien down here in Osceola.
Sí, su señoría, pero el 21 de junio del 2018 él fue hallado incompetente por la jueza O'Brien aquí en Osceola.
Has he been released on conditional release?
¿Y quedó en libertad provisional?
I don't believe so, Your Honor.
I'm confused because he was on bond on another case, which is the one you mentioned, 17 MM 3242. He normally would have been placed on conditional release and not on a bond status. And now he has a new case with new charges, which require bonds to be set unless he has been previously found incompetent and been placed on conditional release. So I'm not understanding what you're telling me.
Bueno, en el caso, en el 17MM3242 fue hallado, se le emitió una fianza, por lo tanto no estoy seguro porque dice que él fue hallado incompetente, porque si él fuese hallado incompetente no se le hubiera emitido una fianza. Y al tener ahora dos nuevos cargos, estoy obligado a emitirle fianza a menos que él ha sido hallado incompetente, pero no creo que ese ha sido el caso.
Yes, Your Honor, you're correct. He is out on bond, but it was because of a failure to appear. This court did find him incompetent, so that's the only reason why we're asking for him to be placed
All
on
right, what
conditional
I'm going to do
release.
is roll this until tomorrow. If you get me a copy of the order finding him to be incompetent by a circuit judge, then the court will consider releasing him on conditional release at that time.
Bien, entonces lo que haremos para buscar el archivo, voy a mover este caso esta mañana y así usted tendrá tiempo para encontrar el archivo o el documento en el que muestre que él ha sido hallado incompetente y trataremos este caso entonces mañana.
I'm going to stay the bond as it is for right now on the new law charges and roll this until tomorrow.
Se mantendrán las fianzas tal y como los había establecido en los casos nuevos por ahora hasta mañana.
State if he has been declared previously incompetent and has not been restored, he's entitled to be released, in fact, cannot be held, but it would be on a conditional release status. So I'll be asking if it does show that to me tomorrow, what conditions you're asking to pose on him under conditional release.
Si él ha sido hallado incompetente, entonces está obligado a dejarlo en libertad con condiciones provisionales, pero hasta que eso haya sido establecido, si no, entonces tendría que mantenerse retenido o con una fianza.
Thank you, sir.
Gracias, señor.
Thank you, Mr. Interpreter.
Not a problem, Your Honor.
Sean Fleck. Where's Mr. Fleck? After Mr. Fleck will be Mr.
he refused.
Forrest.
He refused, Your Honor, Sean Fleck.
All right, let's roll him until Monday, if you would, please. Monday? Monday, there's no point up here at this point, showing that he refused to appear. Christopher Forrest, and then after that, it'll be Lawrence Fosgate, and then Alexander Gonzalez.
Mr. Forrest is here.
Forrest, okay, Mr. Forrest, good morning, tell me your name.
Christopher Forrest.
Okay, Mr. Forrest, you have an arrest warrant that was signed in this matter. The arrest warrant is for trafficking. It has you on a no-bond status. Bond will remain on a no-bond status. That's an out-of-county warrant. The public defender, I assume, is representing you just briefly today in this matter, but you'll be transported. Do we know where this is out of? Brevard County. You'll be transported to Brevard County. If you are not transported to Brevard County, sir, within the next 3 or 4 days, you need to let a judge know over in Osceola County at that time, because you should be transported by that time. Thank you, sir. Lawrence Fosgate. Tell me your name, sir.
Lawrence Fosgate.
Mr. Fosgate, you have an out-of-county warrant also. Bond has been set as none by the judge. It's from Ender and River County. Bond will remain at none. You will be transported. Thank you, sir. Alexander James Gonzalez. Where's Mr. Gonzalez?
Alexander Gonzalez.
Mr. Gonzalez is up there. After Mr. Gonzalez will be Mr. Hancock, and after Mr. Hancock will be Mr. Hernandez Gonzalez. Yes, sir. Tell me your name, sir.
Alexander James Gonzalez.
Sir, do you speak English?
Yes, sir.
Okay, I have 2 cases, sir. One case is a warrant issued that looks like it's on a grand theft. The warrant was issued in this matter. It has set bond at 0 or no bond. It's out of the Orange County Sheriff's Office. The bond will remain at no bond in this matter. Public Defender's Office is representing you. Second case is driving while license suspended in this matter. Bond in that matter was suggested as $500. I'm going to reduce that to $150 in this matter. Appoint the Office of Public Defender to represent you. Thank you, sir.
Thank you.
Todd Hancock. Tell me your name, sir.
Todd Hancock.
Mr. Hancock, I have in front of me a violation of probation or community control. There was a warrant issued by Judge Jankovich down in Osceola County. Bond was set at 0. It will remain at 0 on the violation of probation. Office of Public Defender is appointed to represent you, sir. Good luck to you. Thank you. Burling Hernandez Gonzalez.
He's a Spanish interpreter case.
Okay, how do we let our interpreter know?
Yes,
He listens?
Listen, yes.
Okay. Mr. Interpreter, we need your assistance in this matter.
I'm right here, Your Honor.
Okay,
Aquí.
thank you. Good morning, sir.
Buenos días, señor.
Are you able to speak
Buenos
any,
días.
are you able to speak any English, sir?
¿Puede hablar inglés?
No, señor.
No, sir.
We have an interpreter here to assist you from English to Spanish and Spanish to English. You have a
Tenemos acá un
charge.
intérprete. I'm sorry, Your Honor, go ahead.
Go ahead, I interrupted you.
Tenemos un intérprete acá quien lo interpretará todo de inglés a español y de español a inglés.
You have a charge of operating your
Gracias.
vehicle without a driver's license.
Usted tiene una acusación por conducir un vehículo sin licencia válida.
There is probable cause in this matter.
Determinó que existe indicio de criminalidad en este caso.
I'm going to set bond at $150.
Se fijará la fianza en $150.
Appoint the public defender to represent you.
Se le designará al defensor público para que lo represente.
Thank you, sir.
Gracias, señor.
Timothy Jordan. After Mr. Jordan will be Rafael Martinez Mojeca. Yes, sir, tell me your name, please.
Timothy Meyer Jordan.
Mr. Jordan, you have a warrant issued in this matter by Judge Wooten. There is a bond set in the matter of $2,500. It will remain at that amount. The Office of Public Defender is appointed to represent you. Good luck to you, sir. Rafael Martinez Mojeca. Good morning, sir. Tell me your full name.
Rafael Martinez Mojica.
Okay, Mr. Martinez Mojeca, are you able to speak English?
Yes, sir.
Okay, thank you, sir. I have two cases in front of me. One is a warrant that was issued in this matter. It has set bond at no bond. It will remain at no bond. I think that was issued by Judge Arendis in this matter. In the second case, it is appears to be a new law case of possession of cocaine and possession of drug equipment and for use. I have reviewed the charging affidavit. There is probable cause. Set bond on the possession of cocaine at $2,500, bond on the drug equipment, and amount of $500. The Office of Public Defender is appointed to represent you, sir. Thank you, sir. Mr. Melendez Marrero, Giovanni Melendez Marrero.
He's a Spanish interpreter case.
Okay, we need the Spanish interpreter if we could. Sir, tell me your full name.
Dígame su nombre completo, señor.
Giovanni Melendez Marrero.
Giovanni Melendez Marrero.
Mr. Melendez Marrero, do you speak any English, sir?
Señor Melendez Marrero, ¿usted entiende inglés, señor?
No.
No.
All right, sir, I don't speak much Spanish, so we have an interpreter to help me and you in this matter. Go ahead.
Señor, yo no entiendo mucho español tampoco, así que tenemos a un intérprete que nos ayudará a interpretar todo en este caso.
You have a charge of a battery. It appears to be, from reading the charging affidavit, a domestic violence battery.
Usted tiene una acusación por agresión física, parece ser una acusación de agresión física en violencia doméstica.
I do not see anybody here state, do you have any input from the victim in this matter?
No veo a nadie aquí. ¿Fiscalía tiene alguna información de parte de la víctima?
I didn't hear you, Your Honor.
Do you have any input from the victim in this case?
No, Your Honor.
No, su señoría.
Your Honor, I was unable to make contact with the victim. I did leave the victim a voicemail earlier this morning. I have not received a phone call back.
All right, I'm going to go ahead and I found probable cause, set bond at $2,000. Order no contact whatsoever.
Bien, dado que no se ha podido comunicar todavía con la víctima y no hemos recibido ninguna información de la víctima, determino que existe indicio de criminalidad, fijaré la fianza en $2,000, le prohíbo el contacto con la víctima.
No contact means no in-person contact, no telephone contact, no email contact, no contacting through a third person.
Prohibición de contacto significa nada de contacto, ya sea en persona, directamente o indirectamente, a través de un tercero, a través de mensajes o redes sociales, cero contacto.
You are to surrender all firearms if there are any in the house where you're living or if you own any.
Si usted tiene algún arma o posee alguna, debe entregárselas a las autoridades.
public defender is appointed to represent you.
Se le ha designado defensor público para que lo represente.
Thank you, sir.
Gracias, señor.
This is a long name. It looks like Summer Lake Park, Thequetta Road.
Your Honor, that's
Oh, I'm sorry.
Andy Mendez.
Andy
That's
Mendez.
Andy
Okay,
Mendez,
no
I
wonder I
believe.
was having trouble with it. Andy Mendez.
That's the address, Your Honor.
That's a lot easier. Thank you. Tell me your name, sir.
Andy Mendez.
Mr. Mendez, you have a charge of trespassing in an occupied structure or conveyance. I've reviewed the charging affidavit. There is probable cause in this matter. Does he have a prior history of this? Excuse me just a second. Doesn't qualify for PTR.
Just for the record, he is private counsel.
Oh, he does? Okay, thank you. All right, he does not qualify for a PTR. I am going to set bond at $500 in this matter. I understand from the public defender's office that he has private counsel and therefore will not be appointing the public defender. There's something else here, just a minute. He was on pretrial release and was revoked. Okay, thank you, sir. Brian Mixon. After Mr. Mixon is Victor Morales. Tell me your name, sir.
Brian Mixon.
Mr. Mixon, you have a violation of probation or community control. I think it was the underlying charge was a petty theft. Judge Arendis has entered a warrant and set a bond at no bond. Bond will remain at new bond. The Office of Public Defender is appointed to represent you, sir. Good luck to you. Victor Morales. No, just still a trespass warning. Mr. Morales, tell me your full name, sir.
Victor Morales.
Mr. Morales, I have two cases in front of me here. I have a resisting arrest without violence. I have reviewed the charging affidavit in this matter. There is probable cause. Bond is set at $500 in that case. I also have a case in which there's a violation of probation and community control. It appears that Judge Wooten has issued a warrant and set bond as zero. Bond will remain at zero in this matter. Thank you, sir. Good luck to you. Ronald Randall. Tell me your name, sir.
Ronald Randall.
Mr. Randall, I have two cases in front of me in this matter. On one case, I have a fleeing and eluding law enforcement officer marked patrol vehicle. I also have a driving while license suspended or revoked with knowledge. And I have a second case involving resisting an officer without violence in this matter. There is probable cause in both of these cases. The Office of Public Defender is appointed to represent you in these matters.
Your Honor, he does qualify for PTR, direct PTR.
I saw that here. Does he have a prior history other than these three cases, three charges?
Yes, Your Honor, he does have a prior history dating back to 2007.
His risk
He
assessment,
does have for, yes,
his risk assessment is high, but he still qualifies?
yes, Your Honor, he does. The charges do qualify.
State, do you have a position? They're asking for pretrial release, or says he qualifies for pretrial release supervision.
Secure Watson on behalf of the state. The state has no objection, Your Honor.
We'll try it. I'll go ahead and put him on pretrial release supervision on all three cases, each charge. Thank you, sir. Austin Roman, Austin Michael Roman.
Yes, Your Honor, we'd like to waive the reading of the charges, please.
All right. The court has reviewed the charging affidavit. There is probable cause in this matter. State, do we have any victim input in this matter?
No, Your Honor.
All right. On the one charge that's assessed in this case, I am going to go ahead and set a bond. I'm going to set the bond at $15,000. I'm going to require no contact with the victim. You are not to come within 1,000 feet of the victim's home. No contact means no telephone, no email, no sending a message through a third person, no contact in any manner whatsoever. And the public defender is already appointed in this case. Thank you, sir.
Thank you.
I have Christian Umberto Serrano Galizara. Sir, is that you?
Yes.
Okay, say your name for me.
Christian Serrano Gallarza.
Sounds a lot better when you say it than when I say it. I have two copies. It's just duplicate copies. Both weren't around. Hang on, sir, just a minute. I've got two cases. I'm trying to make sure they're not duplicates. The bonds are identical. Where are you seeing the numbers? I'm just wondering if it's just a double print. Okay. Okay, there are two cases in this matter. In each case, there is a capias or a warrant issued. Bond has been set in each case in the amount of $2,023. It will remain at that. The Office of Public Defender is appointed to represent you, sir. Yeah, it's really a weird bond. It's on both of them. Daniel Edward Tompkins. Where's Mr. Tompkins? Here he comes. Mr. Tompkins, tell me your full name.
Daniel Edward Tompkins.
Mr. Tompkins, you have a violation of pretrial release conditions in this matter under a domestic violence case. I have reviewed the charging affidavit. There is probable cause for that in this matter. The difficulty is you were under pretrial release, and with the violation in this matter, the court does not know any bond that I can impose at this point that would protect the safety of the victim. I'm going to leave this at a no bond, which is what it is right now, but certainly allow you to go in front of the judge to whom this is assigned and see if they can set a bond in this matter, but I don't have enough information to set a bond on this case. Thank you, sir. Public defender is appointed. Carlos Canteras.
He's approaching, Your Honor.
Thank you.
He's a Spanish interpreter case as well.
Okay, we need an interpreter if we could. I appreciate you telling me when they're approaching. They're not in a line of sight that I have.
Yes, Your Honor.
Is he in a wheelchair?
Yes, Your Honor.
Okay, I think I can see a half of him down there. That's okay. Yeah. Do we have our interpreter with us?
Yes, Your Honor.
Thank you, sir. Good morning, sir.
Buenos días, señor.
Can I
Good
ask?
morning.
There, you've read my mind. Thank you, sir. I appreciate you putting that microphone down. Sir, good morning. Do you speak any English, sir?
¿Habla inglés, señor? Sí. Yes.
You probably speak more English than I speak Spanish.
Lo más probable es que usted hable más inglés de lo que yo hablo español.
You have a warrant that was issued in this matter.
Hay una orden de arresto que se emitió en este caso.
The judge in that case has set a bond of $500.
El juez de ese caso ha fijado la fianza en $500.
The bond will remain at $500.
La fianza se mantendrá en $500.
And the public defender is appointed to represent you in this matter.
Y el defensor público será determinado o se le designará para que lo represente.
Thank you, sir.
Gracias, señor.
Pero voy a salir libre para pagar.
Señor, no le entiendo. ¿Se me acerca el micrófono, por favor?
Para poder pagar, voy a salir.
So if I'm able to pay, I can get out?
I'm sorry, say it again?
If I pay the bond, I'm able to get out?
If you pay the bond, you can be released unless there's something else holding you that I don't know about.
Si usted deposita la fianza, quedará en libertad, a menos que haya alguna otra orden de restricción por algún otro motivo.
Your attorney has got somebody in his office. Do you speak Spanish, Mr. Carbone?
Unfortunately not, Your Honor,
Okay.
though we do have social services here
I was
that does speak Spanish.
going to say, if the interpreter can just let him know that there'll be somebody in their office that can't speak to him.
Una persona en sus oficinas podrá hablar con usted, señor.
Thank you so much. Robert Sousa, Robert Allen Sousa.
Your Honor, we'd like to waive the reading of the underlying charges.
Okay, I think
I understand it's an FTA.
Yeah, it's just an FTA is what it is. On failure to appear, the judge has issued, Judge Jacinto, I always say her name wrong, has put a no bond in this matter on the failure to appear. Bond will remain at no bond in this case. Public defender is appointed. Somehow this one got out of order here. That's okay. Coates. Yeah, this is, let me call this one that Tariq Coates, Coats. Good morning, sir.
Yes,
Tell me your name.
Tariq Coates.
Mr. Coates, this is a violation of probation on view. Bond is set at 0. Bond is going to remain at 0 in this matter. Office of Public Defender is appointed to represent you in this case. Thank you, sir.
Thank you.
I have a Alberto Javier Ramos. I can't read the last name. It looks like Kaluma.
Cologne, you got it.
Okay, thank you. This was back in. This is a charge of possession of a controlled substance without a prescription, possession of drug paraphernalia. I reviewed the charging affidavit. There appears to be probable cause. I'm not sure why this was set.
Your Honor, can I make a
Go ahead.
Can I make a probable cause argument?
Sure.
Your Honor, this Florida statute 316.614 requires you to be driving. So, Your Honor, in this case, my client is just sitting in the parking lot. He's not operating the motor vehicle, and he doesn't have a seatbelt on. That's not illegal in and of itself. The statute says that he has to be driving, and he was not operating the motor vehicle, so I don't believe there's any probable cause for the officer to approach him.
You're saying the
Detain him.
stop was bad, is what you're saying.
Yes, Your Honor.
Response from the state?
Yes, Your Honor, to Pure Watson on behalf of the state. As of now, the state has not been provided with any further information from the officer that arrested Mr. Ramos, so the state wouldn't have anything else to add at this moment.
Okay. I'm going to release him on his own recognizance at this point then.
Your Honor, actually, I would ask for him to be straight released. Releasing on his own recognizance is still technically a bond, and if he does pick up new charges, then the RR is effectively revoked, and he would be sitting on no bond in this case. Your Honor, we'd ask for him to be just straight released.
Hang
So
on.
RR effectively is a bond.
Hang on just a minute. All right, I'll go ahead and find no probable cause in this matter, which means he can't be released.
Thank you, sir.
Thank you.
Thank you, Your Honor.
All right.
I'm sorry, I'm pre-trial release and Osceola. How do you want me to write this?
Yes, ma'am.
He found no PC, so how am I gonna release him?
Straight released.
What you want me to put on this?
Ma'am, straight release.
Just put like, okay.
It's a straight release based on that.
And you did appoint PD, correct?
Yes,
No
PD was
PC.
appointed.
Okay.
Yeah, there's no PC. They've had 24 hours and not done anything else. Do you have anybody else there? I think we've run out of papers on Osceola. I just want to make sure you don't have somebody sitting there we haven't called.
I see no hands, Your Honor.
All right, thank you, sir. Appreciate it.
So-
Let me get
Thank
back on here.
He all mute.
Where's the all mute? Okay, we're there. Okay, we're back on here. Can we try and get him in?
Yes, he is the.
Okay.
one on your list.
All right, let me, you have him there?
Yes. Well, we have the one Spanish. Can we do the one Spanish?
We can do-
Here in Orange County, and then he is the next one.
Okay. Let's do the one Spanish if we can. We still have our Spanish interpreter with us?
Yes, sir.
Thank you. I guess we only have one more, so we'll try and get this to you. This is
Appreciate it.
Jamison Edouard. Is he here to bring him brought up? Do they know to get him up here?
Yes, they give them up, yes, sir.
Oh, no, ROR means he can be released if he's ROR like we had one. who Violated a condition of ROR, because there could be conditions of ROR. Then I can take all the bond away. He's right. Tell you, remind me later. I can't say anything here. Is it hot in here or is it just me? I don't remember it being this hot. Now we're going to the headphones. I should tell the interpreter I'm used to the headphones in my courtrooms in the main courthouse. That's why I'm talking over you. I apologize.
Don't worry, Your Honor. It happens all the time. As we're transitioning to the new system, all these things tend to happen.
So your fellow interpreters have trained us to use the headphones, and now we do it and we get in trouble. Or don't do it.
You're spoiled, Your Honor. That's what happens. We spoiled you.
You have. All right. Good morning, sir.
Good morning.
Do you speak any English?
Little bit.
Okay. You speak more English than I speak Spanish, and we have an interpreter here to assist you and assist me. Tell me your full name.
Joshua Valles Martinez.
I'm sorry, say it again?
Joshua Valles Martinez.
That's not who we got.
Joshua Valles Martinez.
Okay, that's not the one I have in front of me. It says Spanish. Hold on, let me get the right one here. It's okay. Got it. Sorry. Sir, I have in front of me a charging affidavit. It charges you with possession of drug paraphernalia and petty theft. I've reviewed the charging affidavit. There is probable cause in this matter. I'm going to set bond on the possession of drug paraphernalia at $150 and on the petty theft at $100.
Are there an offer to resolve this case today?
I don't have any history on him. Do I have a sheet on him? Where are the names?
Takir Watson on behalf of the state. The state does not have an offer at the time due to the fact that the charge could be enhanced.
He also has, from what I'm looking at, a significant history. He has a history of sale and delivery, last conviction of receiving money from pawnbroker, possession of, well, I won't go through them all, there's quite a few.
I understand that, Your Honor, but the charge is a possession of drug paraphernalia and a petty theft. Would the bench have an offer, or?
No, the
Okay.
court's not going to make an offer. All right, thank you, sir. Public defender's appointed. All right, and then we have Mr. I gotta pull this one out. And this you don't need anymore. Do we have one on this guy? Do we need an interpreter for Mr. Beltran?
No, Your Honor, he speaks English.
All right, thank you. Good morning, sir.
Good morning, sir.
Tell me your full name.
Gustavo Adrian Ramos Beltran.
Thank you. And your name, sir?
Amir Ladan on behalf of Mr. Beltran.
And you are representing him in this case?
Yes, Your Honor, we're entering a notice of appearance. Orally, I'll follow up with a written notice of appearance as well.
All right. This is, a capias was issued in this matter, at which point there were 2 charges. Bond was set at 0 on both counts in this matter, with some conditions of no contact with the victim, maintain a separate residence, and do not possess any weapons or firearms. Do you wish to be heard on this?
Your Honor, we would just ask that the court set whatever statutory bonds are appropriate. Mr. Ramos Beltran is in custody on other matters, is unable to post bond, so I don't know that it's really all that material, but regardless of what you set them at, he's not going anywhere. So we just enter a plea of not guilty, ask that you set whatever the appropriate case level bonds are. And if at all possible, I'd like these cases to all be within the same division, so hopefully they find a way to.
The mechanics of that are not hard, are not complicated, but they're not easy. If it's assigned to different divisions, you're going to need to file a motion, first of all, to transfer, and then if you want to consolidate, a motion to consolidate.
Yes, Your Honor, we'll take care of that.
I would suggest, just as a word to the wise, go talk to the judge that you think they're going to be consolidated in front and ask him, with other counsel present, the state present, ask him, would he accept them or she accept them if they're consolidated?
Of course.
I've seen people transfer cases and then judge won't consolidate, and that's a big problem.
Understood, Your Honor.
All right. State, the defense is asking me to set a bond in this matter. This is not a capital charge, I don't believe, the way it's charged. Do you have any position on the bond?
Yes, Your Honor, the state would object to the bond on this case, considering the nature of the offense and the seriousness of the offense. The state would just object. And
What's the legal basis for a no bond?
We weren't provided with an affidavit.
Affidavit of what?
We weren't provided with an affidavit considering, well, a sworn affidavit to tell exactly what occurred. So the state would just be objecting due to the fact that this is a serious offense.
It is as alleged a serious offense, but I don't have any indication that he's not entitled to some bond in this matter. I'm going to set a bond at $50,000 on each count in this particular matter. Require no contact whatsoever with the victim. That means no in-person, no telephone, no email, no contact through a third person. The only exception to that would be if you are with your attorney at a deposition or something of a victim. Obviously, you have a right to be there in that situation. You are also to maintain a separate residence, and you're not to possess any weapons or firearms. If you do possess any weapons or firearms, they ought to be surrendered prior to your discharge or release from the jail.
Thank you, Your Honor.
Thank you, sir. I'm sorry you had to wait so long.
It's what happens on the weekends, Your Honor. I understand how it goes. Have a great weekend.
Sometimes if you let the clerks know early, they can get it up into the bring-ups.
It's quite all right. Thank you, Judge. Appreciate it.
Thank you. We have some other bring-ups we're doing now, or is that it?
Yes, that's it.
These are these, okay, because then I want to get everybody to have lunch if they want. All right, we got them coming up now. This is Vitalis Lisa, Celta.
1 second, Your Honor.
Okay, I'm waiting to get some laughing on my pronunciations, that always happens.
I'm sorry, Your Honor. I don't mean to interrupt. I just don't want to hang up before making sure. Are there any other Spanish cases pending?
I don't think so. You know of any?
We just got one Creole. Do he speak Creole?
How's your Creole today?
Probably worse than your Spanish, Your Honor.
Thanks a lot. Have a good, well, maybe I'll talk to you tomorrow. I don't know.
It'll be someone else tomorrow. Have a good rest of your weekend, Your Honor.
You too. Take care. Bye-bye. Thank you. Good morning, sir. Tell me your name.
My name is Vitali. My last name is Slita.
Okay. Sir, you have a charge of battery on a school employee. I have reviewed the charging affidavit. There is probable cause in this matter.
Your Honor, can I be
Yes,
heard
sir.
as to bond?
Sure.
I would ask for a straight ROR in this case to release him back to his mother. He has no Florida history, no state history, no. This appears to be a first-time offense, Your Honor. I would ask for ROR in this case.
State?
Your Honor, given the fact that he doesn't have any history, the state has no objection.
I will release some ROR with the condition he has to have no contact with that teacher whatsoever, the victim in this case. Let me make sure I've got this correct. Your date of birth is February 27th, 2000,
Yes, sir.
and you are 19?
Yes, sir.
Okay, thank you, sir. Public defender's appointed.
So what's happening to grades now?
Older looking 19. All right. While we're waiting for the next one to get in, can we have both counsel put their names on the record, please?
Oh, Jace Thompson for the Office of the Public Defender.
Thank you.
Takira Watson on behalf of the state.
Thank you. Yes, sir. Is this Michael Vernon Rouse? Is that correct?
Yes,
Okay.
sir.
This was a mental health the other day who was not here. How are you doing today? How are you feeling, sir?
Okay.
Okay, you have a trespass in a structure. I think I had more than that. Hold on here. Yeah, no, this is here, I'm looking. You've had a lot of trespasses. All right, sir, there is probable cause in this matter. I'm going to set bond at $100 in this, just order you to stay away from that property. Do not go there anymore.
Your Honor, is there
Yes, sir.
an offer to resolve this case today?
I don't know from the state. I'm looking, there's a significant history. It says trespass extensive. You've got other charges too, but let me see it's the state's position in this matter. The court's not going to make any offer because I don't have enough history.
The state would offer an adjudication of guilt.
I can't hear you, I'm sorry.
I'm sorry.
It's not you, the printer was printing at the same time.
Oh, okay. The state would offer an adjudication of guilt with 5 days with credit time served and any court costs that may be associated with the case.
We will accept the state's offer and to
Okay.
plead no contest, Your Honor.
All right, you got the paperwork over there? They're getting it to you
Oh,
right
I'm
now.
sorry, my bad.
Let me just toss these.
Your Honor, the
Yes.
state would also ask for a no return.
I think he has a continuing trespass there. We'll put that as part of it.
Your Honor, would you have any objections to reducing all fines and court costs to a civil judgment?
Based on what I'm seeing and the limited information I have no problem with doing that. Thank you, ma'am. Has he been sworn in yet? Swear him in.
Raise your right hand. Do you swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Rouse, tell me you put your hand down. Tell me your full name.
Michael Vernon Rouse.
Are you able to read and write in English, sir?
Yes.
Okay. You understand you had a charge today that we just talked about, which involved a trespass in a structure. You understand that?
Yes.
Yeah. And you understand that I had set a bond on it and appointed an attorney. You were going to be able to go ahead and challenge that charge. But your attorney has told me that you want to go ahead and enter a plea to resolve this case. Is that correct?
Yes.
Have you gone over this plea form with him? I know he was very quick, but did you talk with him about what you're doing?
I signed it.
Okay, I know you signed it. That's your signature?
Yeah.
All right. You think you understand what you're doing?
Yeah.
You understand you're giving up your right to a trial, giving up your right to call witnesses, to see and hear what those witnesses say, giving up your right to make the state prove this case beyond and to the exclusion of a reasonable doubt, giving up your right to remain silent or testify, and giving up your right to appeal except for the jurisdiction of this court and the legality of the sentence. You understand that?
Yeah.
Are you taking any medicines right now?
Hello, Coach. Yes.
I'm sorry?
Yes.
Okay, I know they gave you some yesterday or the other day when you were in mental health visit.
Yeah.
You still taking those?
Yes.
Are you wide awake today, or are you groggy?
Whoa, wait.
Awake? You understand what you're doing?
Yeah.
Thinking straight?
Yeah.
Okay. Anybody threaten you, force you, or coerce you to enter this plea?
No.
All right. I'm going to find you accept the plea, understand that you understand the nature and consequences. You're not coerced or threatened, that your plea is voluntary and of your own free will. There is a factual basis for meeting the charging affidavit, and I'm going to go ahead and accept your plea. I will adjudicate, sentence you to 5 days in the Orange County Jail, give you credit for 5 days' time served, assess court costs, fees, and fines. Madam Clerk, what are they?
He only got 3 days, son.
Or 3 days' time served. Set it at 3 days' time served. Is that correct, State? Are you okay with 3 days?
He only have credit for 3 days. You giving him 5 days, so he get out what, 2?
I think he was thinking it was credit for time served, and I think that's what defense counsel was thinking.
Okay.
Are you okay with 3 days?
State has no objection, Your Honor.
All right, so with 3 days, credit for time served, assess court costs, fees, and fines. Madam Clerk, what are they?
$273.
Total of $273. They'll be reduced to a civil judgment in this matter.
Thank you.
Any questions, sir?
No.
You have 30 days to appeal the decision of this court. If you wish to do so, the appeal must be in writing. An attorney can be appointed to represent you. Good luck to you, sir. Thank you. Okay, we've got, it looks like Paulo Fausto Mandel Joa. I'm never going to get that right. Good morning, sir. Tell me your full name.
Paulo Fausto Mandel João.
A lot better than I could have done. You have a charge of urinating or defecating in public. I have reviewed the charging affidavit. There is probable cause in this matter.
Your Honor, can I be heard as to the charge?
You can, go ahead.
Client's 21 years old, 0 criminal history. Seems like a first-time offense. If it gets transferred downtown, I mean, he'll qualify for a pretrial diversion program. Usually in these cases, client appears to probably be homeless, and he had to use the bathroom. Your Honor, I would ask the court to clear by arrest. It's not a particularly violent charge at all.
State? Looks like he has, from what I'm seeing, no Florida arrest history. Excuse me, I'm sorry.
He has no
Duty judge. No, that's not.
He has no out-of-state history either, Your Honor.
State, your position.
I apologize, Your Honor. What exactly are you?
Essentially, we're dismissing the charges after the arrest.
It's like the arrest is being the punishment in itself and the time that he spent in jail.
Well, as far as just dismissing the case, the state would object to that. There is a sworn affidavit that says that the defendant did commit the crime, but the state has no objection to pleading the case out today.
You want, the court's not gonna go ahead and take it away from the arresting officer in this matter. If you want to enter a plea, we can.
Oh, now, well, since he has 0 criminal history, Your Honor, I would just ask the court to release him on his own recognizance so we could just take care of it downtown.
All right, I will release him ROR based on what I see in this case. Thank you.
Thank you.
Van Michael Brown.
Right here, Your Honor.
Okay.
Right here? Oh, right there. Okay. Sorry, I thought it was over here.
Mr. Thompson, I have several cases I think of his. Do you have them all?
Yes.
Right here, okay.
Sir, tell me your full name.
Van Michael Brown.
Okay, Mr. Brown, I have several cases. I know you were here the other day, but you were not here, but they went, pushed it
Well, I
off.
was in Florida, Orlando Health. I'm in the hospital. I've been in the hospital for 6 months.
I understand that.
They come in and took me out of the hospital and put me in jail.
I understand.
I didn't know there was any
Okay,
hearing.
hang on a minute, sir. Hang on a minute.
Okay, sorry.
That's okay. You have a case charging aggravated assault on a law enforcement
No,
officer.
I would never do that.
Sir,
Okay,
if
go
we're going to
ahead.
go forward today, you
Go
need to
ahead.
let me proceed. I'll give you a
Yes,
chance
sir.
to talk, okay?
Okay, yes.
You have an aggravated assault on a law enforcement officer. I did review the charging affidavit in this matter, but did not to. Judge Alvaro has already looked at it and issued a arrest warrant and set the bond at $500. Bond will be stayed at that $500. You also have a second case, which is a failure to appear. It's a trespass in an occupied structure.
I've been in the hospital for 6 months.
Hang on a minute, sir.
Oh, good.
Bond was set at $1,500 on that. by the judge who issued the warrant. It will remain at that. You have a third case, 6222, which is failure to appear, $2,000 bond. $2,000 bond has been set by, again, a judge who issued the warrant in that case for failing to appear. And you have a last one, which is another failure to appear. And the judge has also issued a $2,000 bond in that, and that is in case number 9830. The bonds will be as set forth in those matters. If you were in the hospital, sir, your attorney is the public defender. They will represent you. They can file a motion to have those matters explained as to what's going on. On the other case,
Well, can I get out for free trial release or something? Your
no,
Honor?
sir. No, sir. The judges in each of these cases have already.
Oh, in other words, I can bail what?
On this case, right. So you want to take action on it?
You also were already out on bond.
Yeah, was I on, yeah, I was in the hospital for 6 months. I busted my legs.
Sir, hang on a minute. 2019 MM 0092447 AO. You were out on bond when these charges, some of these charges were incurred. The court is going to go ahead and revoke bond in that case.
Would you hold it at no bond, or would you stand a bond? in that
No
case?
bond.
No bond.
I
In
can't
that case.
get a bond.
All right.
We got file motions downtown, so the attorney that's gonna be on your case is gonna get in contact with you, and we'll take it from there.
All right. And this Felicia Fordyce. Seems like we're dragging a train behind us today.
I have a Michelle Fort.
You have a who?
A Michelle Fort.
I don't have a Michelle Ford. Oh, I do have her farther down the list. I'm not sure. Maybe they got out of order. Is this Michelle or is this Felicia? Is this Felicia? Let's get Felicia down if we can. You have that there?
I'll find it.
Okay. It's Felicia Shirelle Fordyce?
Yes.
Am I even close saying that? I usually don't get the names right.
Yes, sir.
Okay, thank you. You have a charge of trespass on property after warning. Review the charging affidavit. There is probable cause. I'm going to set bond at $150 in this case.
Is there
Public defender.
offer to resolve the case? Yeah. Are you on probation right now? I just don't think that's keeping you in.
Yes, Your Honor, the state would offer an adjudication of guilt with credit time served, no return to scene, and any court costs associated with the case.
You want to do that?
Yes.
We'll accept that, Your Honor, and to plead no contest.
Okay, let's go ahead and get the form filled out. You just swear her in, please.
Raise your right hand. Do you swear or affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
Yes.
And she got how many days? 2 days?
That's signing right there.
Ma'am, tell me your full name.
Felicia.
You swear? Yeah.
Felicia
Okay,
Fordyce.
thank you. Ma'am, you understand that you have the charge of trespass on property after warning?
Yes, sir.
You understand that by entering this plea, you're giving up certain rights?
Yes, sir.
You understand you'd have a right to go to trial if you wish to have this heard by a jury in this case. You could call witnesses, hear what they might have to say, cross-examine those witnesses, and the state would have to prove this case beyond and to the exclusion of a reasonable doubt. You understand that?
Yes, sir.
You also went to trial. You could testify at trial, and you could decide, I'm not going to testify, and the state would have to prove this case without testimony.
Yes, sir.
You understand you're giving up your right to appeal except for the jurisdiction of this court and the legality of the sentence.
Yes, sir.
And you understand, are you using any medications right now?
No, sir.
Have you used any illegal drugs in the last 48 hours?
No, sir.
Is there anything about your physical or mental condition that makes it difficult for you to understand what I'm saying?
No, sir.
Have you understood everything your attorney has said to you?
Yes.
Plea negotiations in this matter and adjudication, is it 2 days credit for time served, is that correct?
Yes.
2 days credit for time served, no return to the scene, and there'll be some court costs. You understand that?
Yes, sir.
And you want to accept this plea?
Yes, sir.
Find you understand the nature and consequence of your plea, that you're not coerced or threatened, that your plea is voluntary and of your own free will. There is a factual basis. You're represented by competent counsel, and I'm going to go ahead and accept your plea. I'm going to adjudicate, sentence you to 2 days in the Orange County Jail, give you credit for 2 days' time served, require that you not return to the location where this trespass occurred in this matter. Assess court costs, fees, and fines. Madam Clerk? 273?
Yes.
$273. They are to be paid at the rate of no less than $25 a month, starting no later than 60 days from today, to give you some time to get some basis for paying them. 30 days to appeal the decision of the court. If you wish to do so, the appeal must be in writing. An attorney to be appointed to represent you. Yes, ma'am. Anything else?
No, sir.
Thank you.
Thank you.
Okay. Denise Fort. Okay, if you come up next to your attorney there, ma'am. This is, tell me your full name.
Miss Denise Fort.
Okay, Ms. Fort, are you able to read and write in English?
Yes, I can.
Okay. You have a charge of trespass on property other than a structure, the conveyance or curtilage. I've reviewed the charging affidavit. There is probable cause in this matter. I'm going to go ahead and set bond at $150. You also have a second case. That's case number, I believe, 2019 MM009142AO, which was a similar charge of trespass in a structure. You were on a bond on that case. I am going to revoke bond in that matter, since this is a second type charge of a similar type. Public defender is appointed to represent you in this matter.
I just want to inquire with the state if you have a global plea for both charges.
Court's not going to accept a plea today on that case. Not with other charges that I haven't had a chance to look at, and a victim hasn't had a chance to have any input in. Thank you, ma'am. Denise Sampson.
Here.
Your Honor, before we go to the next, if I may ask what the bond was on the previous case, just to confirm that I have the correct number.
$100.
100.
Thank you.
Thank you. Denise Sampson. Ms. Sampson, tell me your full name.
Denise Sampson.
Sampson, you have, and you're able to read and write in English, ma'am?
Yes.
All right. You have an arrest affidavit that shows possession of methamphetamine, possession of heroin, possession of cocaine, possession of drug paraphernalia. I've reviewed the charging affidavit in this matter. There appears to be probable cause in this case. The Office of Public Defender is appointed to represent you. Let me look at one thing here if I can. You don't have a significant prior history. So the bonds, because the bonds that were suggested here are lower than I normally would impose, but I'm going to leave those bonds in effect.
Y'all, can I make a, this is Denise Sampson?
Yes.
Can I make a bond argument? Your
Sure.
Honor? I would ask that you release RORs to all charges. Per our records, she has zero criminal history whatsoever. No in-state, no out-of-state. It's my experience that once this case moves downtown, she's going to qualify for a pretrial diversion program, Your Honor.
She may and she may not with the different types of medications that she had, of drugs that she had there. I'm not going to release her, or I'm going to leave a bond set the amount of $1,000 on the first 3 counts and $500 on the last count. Excuse me, $100 on the last count. The possession of drug paraphernalia would be $100. $1,000 on each of the 3 counts.
We'll get you a bond.
Can PTR do drug testing on her even if they're not supervising?
Yes, sir.
All right, I'm going to order drug testing if you would, please.
Could she also, why wasn't she qualified for pretrial release?
She was interviewed at the time.
She wasn't interviewed? Could my client be screened for pretrial release? And
That's up to you. We've got to get through these. I can't keep going back over cases.
all right,
So if they want to, if she want to ask her to do that, that's fine.
okay.
Can you have it if she's going to be interviewed for PTR? If she does not qualify, she still have a bond?
Still want drug testing.
Yeah, okay.
Yep.
You want to do bond or pretrial release if she qualifies with?
No, it's going to be a bond. It's going to be a bond with drug testing.
Okay, that's it, no.
If she qualifies for pretrial release, then obviously the drug testing will be included in that. There'll still be a bond. All right, thank you.
So you don't want, okay, I got the bond, we ran the UA through pretrial release.
Yep.
But if she qualified for pretrial release.
She's still file a bond.
I know, okay, so it's
Okay,
bond.
bond and pretrial release. Terrell Edward Davis?
Yes.
Okay, Mr. Davis, good morning. I guess it's afternoon now.
Good morning.
Let me see here. You had a mental health hold on it the other day when you were up here. Let me find my notes. You had a battery charge in this matter. I've reviewed the charging affidavit. There is probable cause in this matter. And anything on him? I guess there's not. A bond is at $500. You are to have no contact with the victim in this case. Public defender is appointed to represent you. Check with your attorney there, sir, before you tell me something.
Okay.
I'm sorry.
I want to speak to him. I want to speak to him.
All right, Your Honor, despite my legal advice, client would like to address the court.
You're welcome to address me, sir. I want you to understand anything you tell me, everything you tell me is being recorded.
I don't want to tell you nothing. I just want, only thing I'm asking y'all, I got more, if you got my record up there, I want to get this over today if y'all allow me to, because I got bigger things to do in another state. I'm a fugitive of justice. And at the same time, I want this misdemeanor to be over with so they can come get me.
We're not going to be able to resolve this today. Your attorney may be able to work with the state attorneys on this case, but we're not going to resolve it today. I've entered a not guilty plea, appointed the public defender to represent you.
But I want to enter a guilty plea.
You can enter a plea of guilty, but the court's not going to take it today. As soon as it's assigned to a judge, you can take it.
So what is my bond now?
Your bond in this case is $500.
I just bond now and they'll come get me.
Your Honor, where are we at in the docket?
These are just some pull-ups is all we are.
Oh, okay.
We've only got like 2 more, and then we're going to break.
All right.
We're way out of whack normally from where we usually are. This is David Edward Manuel.
Yes, sir.
Okay. This is Mr. Manuel. This was a mental health yesterday, so this is a callback again today on it. This was, looks like the Judge Epperson has entered the order in this matter, set an arson of a conveyance, set a bond at none in this matter, in the arrest affidavit, and that's where the bond is. That bond will remain at none. Let me look. He had another case, I thought. He already has an open case, looking for the number, 2016 CF 011820.
You should have another judge on 2012.
He also has a 2012 case, CF 010195. That case was an aggravated assault with a deadly weapon, aggravated fleeing and attempting to elude, grand theft of a motor vehicle. The other one was burglary of a dwelling and criminal mischief. Okay. Public defender is appointed. Bond is going to remain as was set in the arrest affidavit signed by the judge. You can certainly appear for a bond hearing in front of the judge to whom this is assigned.
So the 2 cases that he's out on bond.
I don't know whether he's out on bond on those. It says open case, it doesn't say anything
Oh,
about
it's just
bond.
saying, yeah, just, so you're taking no action on,
Yeah, there's nothing for me to do because they're just
Okay.
open cases.
okay, and then his, the new one arrest 2020 CF 2383, the one is there, the bond staying at 9?
None. Yeah, that's the
Aggravated,
169720.
aggravated assault with a firearm and criminal mischief.
No, you got me.
I'm sorry. Yeah, he got, okay.
This is a different case. This is
Yeah.
not ours.
Yeah, the 2 cases out on bond.
This is the one we have.
Do we have, right, then he should have another. Another. I'm sorry.
Oh, wait a minute, maybe
You
it's
got
this
it right
one.
there? Okay, yeah,
He has a second case also, which is 2020 CF 2383. It's in front of Judge White. That's aggravated assault with a firearm and criminal mischief, $200 or more. There was a mental hold on that, but I don't have the arrest affidavit on that one. Not on that one. So bond's going to probably need to remain at none for right now. Mr. Thompson, I think the judge this is assigned to is going to need to set this for a bond hearing in front, because he's got so many different cases, and they're kind of commingled. He may be able to get a bond, but it needs to have one person looking at the whole thing. Okay? So bond will remain at none of those. All right, and we did this, is that all of them?
You got the, oh, that's, the Creole, I have to call.
Which one is that?
The one that got in hand right there, it says Spanish.
Jamison? Oh. Okay, Jamison Eduardo, I guess, is a Creole.
Okay, let me call the language line.
Okay. Folks, while she's doing that, we're going to take a break here in just a few minutes, and I can try and finish up reading the Orange County ones, and they should be normal, back into normal thing. We got the bring-ups and everything else. It's been crazy this morning. We have somebody sitting out there? For the Creole? Do we know who it is? Is it victim or victim?
So both of them need an interpreter.
That may be a problem for the interpreter.
Creole. Yes, please. It's one for a court proceeding. I need one for a court proceeding. Yes.
Mr. Thompson, have you been able to communicate with him?
Oh, no, I have not, God.
Okay.
Yes, I need you to translate in the court proceeding from English to Haitian Creole. I have a victim and a defendant that need to go interpret, so I'll put you on hold and Judge can ask you a couple of questions. Okay? Okay, Judge, next, the time to talk. Is he talking? Oh.
Here?
Yes. Okay, so he should be there.
Hey, good afternoon. Do we have the Creole interpreter on the phone?
Yes, sir.
Thank you.
I am the Creole interpreter.
Thank you for joining us. We appreciate it. This is first appearances this morning, and the gentleman is coming in. His name is Jamison Edouard, E-D-O-U-A-R-D. And he is at the podium now. Does he need the headphones on, or I guess he can hear over the speaker? All right. Good morning, sir. Do you speak?
Bonjour, monsieur.
Do you speak English?
Est-ce que vous parlez anglais?
No.
Do you speak Creole?
Yes.
Okay, we might need to move that microphone down a little closer to him. We have a gentleman on the phone who is listening to us, and you can hear him on the speakers.
Nous avons moun nan téléphone nan, ou capable tandem nan haut-parleur.
He's going to interpret for us.
Et m'pral traduire pour vous.
Okay.
The gentleman standing to your left is the attorney who will be representing you in this case.
Et monsieur qui campé à gauche ou c'est avocat, c'est lui-même qui a représenté ou dans cas ça.
Tell me once again your name, sir.
Et dis-moi encore une fois comment on relève.
Jamison Edouard.
My name is Jamison Edouard.
All right. You have a charge of aggravated battery.
You accusé de voie de fait.
And also a charge of assault and a charge of battery.
Et you accusé ou assaut ou agression au monde et puis ou battre.
I have read over the document that the police gave me.
Et moi lis document que la police ba moi,
which is called the arrest or charging affidavit.
et qui ça relé c'est un affidavit d'arrestation.
And there is probable cause in that affidavit.
Et il y a une cause pour ça.
One
Pour faire affidavit ça.
One of the big concerns the court has
Il y a un problème qui concerne le tribunal là.
in reading the affidavit.
Pendant qu'on a pris affidavit là, déclaration,
The court was advised, and I'm going to read this statement to you.
et yo conseiller tribunal là, ça pour le faire, et moi lire qui ça dit.
Joanne and Edouard have been abused. Joanne said Edouard has been abusing her physically.
Et Joanne dit que Edouard abusé physiquement
for the past 2 years,
depuis 2 ans.
but she
que ça va
never
faire.
called the police
Et elle pas jamais relé la police
because Edouard told her
parce que Edouard a dit
that he would kill her and her daughter if she ever called the police.
parce que Edouard a dit moi si moi relé la police, l'a tué ni moi ni petite fille non.
That is a concern to the court in setting a bond in this matter.
Et c'est exactement ça. Et le tribunal là concerné qui fait que il a exigé une caution.
Mr.
En cas ça.
Mr. Interpreter, we have a witness here on this case too. I don't know whether she speaks Creole and English or just Creole, but let me check here for just a moment. Ma'am, what is
Okay,
your
sir.
name?
My name is Joanne Zephy.
Do you speak English, ma'am?
No, I speak Creole.
Creole?
Yes.
We have an interpreter here today who is helping us, and he will interpret for me, but what you're saying is piped into the courtroom so that Mr. Eduardo can hear it. What did you want to tell us, ma'am? First of all, how are you related to him?
OK, madame Limando, qui relation qu'on gagne avec monsieur Edouard?
Moi, avec M. Edouard, nous mariés, nous avons un petit ensemble avec. Mariés juillet mois de juin, 27 2018. L'homme fin accouché, marié ensemble avec nous, une close, nous étions dans le cas ensemble avec.
27 juillet, excusez madame, est-ce que, excuse me, George, there's something I'm kind of confused about. I'm going to ask her again, please.
Okay, thank you.
Okay, qui l'a marié?
Moi, marié 27 juin 2018.
2018. Et on petite fille avec elle.
Oui, j'ai une petite fille ensemble avec.
Okay, all right. Mr. Edwards is my husband. We're living together, and we've been married since June 27, 2018, and we together have a daughter.
Is your name Joanne?
Est-ce qu'on est Joanne, madame?
Oui, moi, je suis Joanne.
Yes.
And you
My
were,
name is Joanne.
You were the victim in this case, is that correct?
Est-ce que c'est vous-même qui victime dans le cas ça?
Oui.
Yes.
The court has to decide what bond to set and whether or not he can return home. What do you want to tell me about
OK. Et donc le tribunal là vient pour le décider qui caution pour imposer contre lui et qui gens sous qui conditions pour le retourner à la caille. Qui sont pour dire dans ça?
Ok, moi je peux dire ça. Je voulais pour monsieur rester loin parce que je pas venir un problème ensemble avec, je voulais pour monsieur rester loin. Je pas dire pour pas venir ouais petite, mais il ka venir ouais petite, mais il pour rester loin.
Okay. All I have to say, I would say that Mr. Edward has to stay away from me, very far from me, but also he can come and visit his child, and that's all. But I want him to stay away.
You do want him to stay away from you.
Donc, question, madame, est-ce que vous voulez pour le rester loin?
Oui, moi je voulais ça.
Yes, that's what I want.
Would you be concerned at all about the child being hurt if the child was with him at all?
Can you repeat that for me, Your Honor?
Yes. I'm asking Joanne whether she would be concerned if their child might be hurt if he were to have contact with Eduardo.
I understand. Est-ce que, par exemple, vous n'avez aucune idée ou bien concerné que les capables de faire petit pour un bagage mal, le vient visiter?
Non, je n'ai pas aucune idée si le café mon bagage mal, mais je voulais le rester loin. Je voulais le rester loin. Je n'ai pas idée de ça si la fait mon bagage mal.
Bah, ou même non petite là?
Oh, petite là, non. Je ne
Yeah.
connais pas si la fait là. Je ne connais pas si la fait petite là, aucun mal.
Okay, donc vous ne pouvez pas répondre ça. No, I cannot answer that. I don't know if he's going to hurt the kid.
Okay, all right. Thank you, ma'am. Is there anything else you want to tell us, ma'am?
Madame, est-ce que vous avez encore que vous pouvez ajouter?
Non, je voulais connaître qui est monsieur à blaguer parce que je ne connais
Vous voulez qu'on qu'il ait la gueule?
Oui.
No, all I want to know when is he would be released.
State, do you have a position on bond in this matter?
Yes, Your Honor, the state would object to the defendant having a bond in this matter. Considering, well, the state feels that the defendant is a danger specifically to the victim. The victim has children, and according to the sworn affidavit by the officer.
Whoa, you got an interpreter here.
Oh, I'm so sorry.
That's okay.
I'm so sorry.
Do it in phrases.
Okay. The state would object to a bond in this case.
Okay, que l'avocat dit que il n'est pas d'accord pour monsieur et on caution
The state.
pour sortir.
The state would argue that the defendant is a danger to the community, a danger to both the victim and the children in this case.
Que monsieur son danger, que monsieur doit c'est son danger pour la communauté et un danger pour et madame non et petite.
According to the sworn affidavit provided by the officer, domestic violence, there is a history of domestic violence from the defendant.
Et selon déclaration que la police fait sous affidavit là, monsieur gon histoire de violence et de violence familiale domestique et de violence domestique.
So considering all of those factors, the state would argue that the defendant should have no bond.
Et en considérant tout problème ça yo, et l'État donc dit que monsieur pas doué sorti dehors sous caution.
Is there any legal basis for me not to set a bond in this case?
Question, est-ce que y a aucune base légale pour empêcher que au bail monsieur Edouard on bande et la gueule sous caution?
Give me one moment, Your Honor.
Avocat dit ballon petit moment. On est juste à un petit moment.
No, Your Honor, the state is saying that there is no legal basis for there not being a bond.
Donc, réponse avocat dit non, juge, pas aucune base légale pour empêcher que vous mettez le dehors sous caution.
Defense, your position on bond?
Your Honor, client has zero criminal history whatsoever.
Et juge, mon client n'a pas aucune histoire criminelle du tout.
All we have to go on today is the arrest affidavit.
Et selon les déclarations qu'ils fait sur affidavit d'arrestation,
And while it does support probable cause for the offense,
et pendant que il y a des causes probables
it is written.
offense, ça le fait,
It is written by the police officer.
et que la police écrit avec main,
It has the victim's input,
et avec sa victime, déclaration victime, non?
without my client's input.
Et sans que client n'a lui-même pas fait aucune déclaration.
And at this point, they are just allegations.
Et pour le moment, c'est simplement des allégations.
Under the laws of the state of Florida, my client is entitled to a bond.
Et selon la loi en Floride, client n'a bien droit à une caution.
His risk assessment is low.
Can you repeat that for me, sir?
His risk assessment is low.
OK? Et risque, évaluation, monsieur va poser un gros risque.
He's been gainfully employed for the last 4 years.
Et monsieur la travaille très bien en côté. Et monsieur a 4 ans de travail en seul côté.
And he does qualify for pretrial release.
Et il qualifié pour la gueule sans caution.
The defense will ask for pretrial release.
Et il m'a demandé pour mettre le dehors avant que juge.
And if the court finds that pretrial release is inappropriate,
et si le tribunal a trouvé que a fait que la gueule avant jugement, avant procès,
we will ask for a bond in the amount of $1,500 on count 1.
et nous demander pour avoir une caution $1,500
and 100 in count 2 and 100 in count 3 as subsidiaries.
et $100 pour accusation 1 et $100 pour accusation 3 et la trier.
Thank you. The court is aware that he is entitled to a bond. The court does have significant concerns for the safety of the victim based on comments contained. Go ahead, sir.
Et le tribunal a trouvé que yes, il y a droit à une caution, mais en même temps tout, le tribunal là est très concerné sur qui Jean-Monsieur agit.
I am going to set bond as to count 1, the aggravated battery, in the amount of $15,000. As to count 2 and count 3, I'm going to set bond at $100 each.
Et suggérer un bon pour $15,000 pour account 1, batterie et assaut, et l'autre account 1 et 3, $100 chaque.
Going to require he have no contact with the victim.
Et nous demander que il ne prend aucun contact avec victime, non?
That he maintain a separate residence.
Que là, cherchons l'autre côté pour l'habiter.
That he not return to the residence except on one occasion to collect his belongings with law enforcement.
Et que pour le retourner dans le cas là, la retourner une seule fois dans le cas là, c'est pour la prendre tout ça le posséder et il faut qu'il accompagné par police.
He is not to consume any alcohol or illegal drugs.
Il n'a pas droit boire alcool ni prendre drogue illégale.
He's not to possess any weapons or firearms.
Il n'a pas droit posséder aucune arme ni aucun zam. Zam à feu, il pas droit à ça.
And any firearms or weapons are to be surrendered at the time of his release.
Et s'il gagne zam ou un revolver et zam à feu, il fait pour mettre le bas la police, le la gueule.
Public defender is appointed.
Et il y a bali un avocat de défense publique.
He may have supervised visitation with his child.
Et s'il besoin à visiter petit Lio, c'est visite supervisée pour le gain.
And that can be done, I can't remember the name of the place, but there's a place here in Orlando that allows for visitation, supervised visitation. But I'm drawing a blank.
Et il a fait ça, visite supervisée, de mon côté dans Orlando, pas son adresse, pas son nom. Là, c'est là où fait visite supervisée.
Is there anything else from the state?
Nothing further from the state, Your Honor.
Anything else from defense?
No, Your Honor.
All right, Mr. Interpreter, thank you so much. I know it was difficult for you today with the two folks here.
Okay. Thank you, Your Honor.
Thank you.
Thank you, sir. Thank you for using our service.
I think that's it. Okay. Folks, we're going to take a break. It's 1 o'clock. I've got to still read the stuff from this afternoon, although some of it was done this morning. It's not. Okay. It's probably going to be at least an hour for me to get through those things. We'll try and do it as quickly as we can. Apologize. Okay. Thanks. Crazy day. Oh, you start pulling them out of order and then take quick as they slip. That's of course Creole interpreter. All right, we'll go ahead. I'll get through those other things that are in here. So let's plan on possibly 2 o'clock. Okay. Thanks. Hopefully there's no more warrants.
You know, I'm gonna hurt you. I'm gonna hurt you. And you signed the plea, they get the, there's a new form, it's a new plea form that Judge.
Well, that's the plea form that was downtown. So.
Judge, we tell me this one here?
Yeah, I'm used to that. I'm used to that plea form, yeah.
We wasn't using it. So the pink copy is for the defendant, so then you can pull it off and give it to him.
All right,
Okay.
that's cool. Sampson, I think he meant pre-trial release or bond.
I put it on.
Okay.
Yeah.
All right.
But it's from UA either way.
Yeah, all right.
Either bond with through pre-trial release or pre-trial release with random UA. Okay, I got it. And all these goddamn go pleas are slowing us up. And you know you should get him, instead of him setting him on a payment plan or reducing to a silver, just give him a year to pay. Just say, Judge, come give me a year to pay. And I can put it on there, how long when they supposed to pay. And it go quicker that way. Because I got to type out an order. I got to get him to sign it. I got to explain to him what the order is. You killing me. I said, Lord, I see you wait till court. It ain't like you don't know. Oh, that's you felony now, huh?
Yeah, I'm a felony now.
Do you like it?
I like it way better. But the man, like,
who is your judge?
Beamer.
Oh, okay. She a new kind of new judge.
Yeah, you're really good. But the offers are like, I used to think Edie was tough when she was like 7, 10 days. Man, my lowest offer is 9 months OCT.
Oh my God.
I got a guy, we're about to go to trial, or he papers, but he's facing 30 years.
Dang.
For a bird, and all he did was smash, open a car window and put some stuff inside. So burglary conveyance, he got like 6 counts of that. That's 30 years. And then they're offering me 5 years prison. That's the plea. I'm like, so it's.
Like, yeah, it ain't like he broke.
Exactly. I mean, like,
broke in the house and had people hostage and shit. Damn, 5 years for just breaking the car window and taking out a.
But you know what?
Learn, huh? Yes. Oh my God. Finally. Oh my. Oh yeah. You got.
So when do we start doing move up first? Move up first. Yep. You said like an hour, right?
Yeah, you said about 2 o'clock.
And I'm sorry, State. I didn't mean to interrupt, but the Creole, cause he
yeah, I forgot. I forgot.
And I can't stand Creole. Woo.
I know, cause that's long.
It's so long.
And I'm like, what is he telling her? Because that ain't what the judge is saying. He's saying stuff. I mean, if she answered him, then he said something back. I'm like, that ain't how it works.
The thing I don't like about the Creole is they be speaking English.
Yes. Yes.
They know English, man. They waste all
She
the time.
answered it. Yes. Do you not know I can read Creole?
Just like the Spanish one.
Ooh, geez.
Talking in English.
That's what I said. I said, Lord have mercy. They're killing me here. Okay, sure. Let me give you your I put on that bond or pre-trial release is qualified, and I marked both sides. The ran, if he give up with the ransom, because he was confused. Me. Oh, Jesus.
I was confused too. I was like,
It's a right here. She look right at
either or.
Either or.
The move up list. What you mean?
Because the move up is right here under his
But
phone.
you know every damn thing, but
So I
you
said,
don't even know the
okay.
damn boy to be going in. Tell you what that
And he
is.
told the girl, write your name on the paper. Cause
If
he
she
don't
get a
wanna
bond,
write it.
Yeah, 'cause you don't want to write the name.
if she get pre-trial release, it's brand
Write
new.
your name on the paper.
That's why he kept looking every time he looked at me. What you looking at me for? The paper's right over there. That's your job.
People see your face.
Write your name on the
You
paper.
so much
You
better
gotta
than
change
her.
something. Why you can't write her name on the paper?
That's your job.
That's what he told the girl, write your name on the paper.
No, you Chase need to write his.
That's why he telling them, write your name on the paper. I said, no, write the name on the paper.
Tell
Tell
Jace.
her, write your name on the paper.
Tell
And
Jace.
sign it at the
No, we ain't
bottom.
telling him nothing, cause he don't like listen to us.
I'm gonna tell him. Chase don't tell them to write it. Just sign it. Let them sign it. I write. Don't have cause What if we gotta put on there?
No, I just want to explain exactly what I had, because I don't know how to put it in system.
She either post the
That's the
bond
sorriest thing
with
ever.
Brandon through pre-trial.
I hate to see you.
Or
fall.
pre-trial release with
Okay.
Brandon UA.
When I see him in the morning, I was
Because
like,
he
oh.
want to do the random UA, because if she qualified for pre-trial, then yes. My grandbaby's probably me mom.
Yeah.
Me mom. Okay, it's better than grandma.
He said that when he was little. Okay. Is this Mr. Benson?
Yes, sir.
All right, tell me your full name, sir.
I'm J. Tony Benson.
Mr. Benson, you have a arrest affidavit charging battery by strangulation, domestic violence, a second count of the same, and a strangulation and a battery domestic violence. I have reviewed the charging affidavit. There is probable cause in this matter. The officers did not recommend a bond. We don't on these. I reviewed, as I say, the specific fact situation in this case. As to the first strangulation, domestic violence, the court's going to set a bond of $15,000. As to second count, battery by strangulation, $1,000, and the battery domestic violence, $500. You are to have no contact with the victim whatsoever. You are to maintain a separate residence. You are not to return to the home or the scene. If you have any belongings there, you may return on one occasion with a law enforcement officer to collect your belongings. You are not to consume any alcohol or use any illegal drugs or any prescription drugs outside of the confines of your prescription. You're not to possess any weapons or firearms, and if you own any, they are to be surrendered at the time of your release. Public defender is appointed to represent you, sir. Jerry Nicholas Foster? Nicholas Foster.
Yes, sir.
Yes, sir. I have, first of all, I understand, are you going to be hiring your own attorney, sir? Your financial affidavit you filed showed you did not qualify.
No, I ain't say I was gonna hire my own attorney.
Well, the problem is you're making $800 weekly, is that correct?
No, every 2 weeks, $400 a week. Get paid bi-weekly.
Okay, all right, it just got mixed up on here, okay.
Yes, sir.
All right, I'll appoint the Office of Public Defender to represent you. You have a warrant that was issued in this matter. The judge has set bonds on count 3 and count 4 of $1,000 and $150. Those will be stayed. As to the battery by strangulation, I did review the arrest affidavit that went with it and the affidavit in support. I am going to set the bond at $15,000 on the battery by strangulation and $1,000 on the battery domestic violence. So it'll be 15,000, 1,000, 1,000, and 150. You are to have no contact with the victim. You are to maintain a separate residence. You're not to return to the scene. You may return on one occasion with law enforcement to collect your belongings if you need to do that. Thank you, ma'am. If you need to collect your belongings, you're not to consume any alcohol or illegal drugs. You must use any prescription in the confines of the prescription. You're not to possess any weapons or firearms. You are to surrender any firearms at the time of your release. You do have a prior case, which you're on pretrial diversion, I believe, in this matter.
Yes,
The
sir.
court's not going to take any action on that DUI, although I suspect the prosecution is going to ask for some action to be taken in case number 2017 CT 000178. Thank you.
Okay. Thank you.
Sign this for you. Okay. Philip Hagenwald?
Hagerwalt.
Hagenwald.
Yes,
Thank you, sir. I have reviewed the warrant arrest affidavit. The judge has already set a bond on the aggravated battery on a pregnant person of $3,500. The court has to set a battery on the battery by strangulation, a bond on battery by strangulation. I have reviewed that. I'm setting the bond at $15,000 on that. You are to have no contact with the victim. That's no contact of any sort. You are to maintain a separate residence. You're not to return to the scene. You may return on one occasion with law enforcement to collect your belongings if you need to do that. You're not to consume any alcohol or illegal drugs. If you're taking any prescriptions, they are to be taken within the confines of the prescription. You are not to own or possess any weapons or firearms, and if you have any, they are to be surrendered at the time of your release from the jail. Public defender is appointed to represent you in this matter, sir. Thank you. Terence Tyron Taylor. Are you Mr. Taylor, sir?
Yes, sir.
Mr. Taylor, you have a charging affidavit that is aggravated battery on a pregnant person under dating violence, also false imprisonment. You also have case number 2020 CF002077, at which you are on bond for and were at the time of this event, which is a possession of cocaine with intent to sell and deliver with a firearm, carrying a concealed firearm, and possession of a drug paraphernalia. I have reviewed the charging affidavit. There is probable cause in this matter. We have somebody here on this case. Ma'am, are you here on Mr. Taylor's case?
Yes.
What is your name?
Jocelyn Carrion Mitchell.
Okay, and what is your relationship to Mr. Taylor?
His girlfriend.
Okay, that wasn't difficult. I just needed to know.
I'm sorry.
That's okay. Are you here to tell me anything, ma'am?
No.
One of the things the court's got to determine is if he's going to be released, what the conditions of that release is going to be. Were you one of the victims in this case?
Yes.
If he's released, do you have some concerns for your safety?
No.
None at all?
None.
Okay. All right. Do you want him released?
Yes.
Anything else you want to tell me?
No.
Thank you, ma'am. I am going to go ahead in this matter and set bond on the aggravated battery to a pregnant person of $3,500, false imprisonment at $1,000. Appoint the office of public defender. I am going to require, at least for now, that you have no contact with the victim in this matter, and you maintain a separate residence. You're not to return to the scene of the offense. You may return on one occasion with law enforcement to collect your belongings. You're not to consume any alcohol or use any illegal drugs. If you're taking prescriptions, they are only in accord with the prescription. If you own any weapons or firearms, they are to be surrendered at the time, and you're not to possess or own any firearms in this matter. I am mindful of what your girlfriend or roommate has said. I have no problem with your approaching the actual judge in this case. You can have your attorney file a motion to modify the conditions of release. But for right now, without having a full history, I'm going to require that you have no contact. Public defender is appointed to represent you in this case.
For the case, Anna, you're taking no action?
Oh, I'm sorry. I did forget. You, on this other case that I mentioned earlier, you have a surety bond in that. In light of the charges in this other case, I'm going to revoke the bond in the case number 2020 CF 2077. Thank you. I meant to do that. Hey, Zeus Alberto Leone?
Yes, sir.
Okay, give me just a second, sir. Let me catch up here. All right. Sir, you have a charge of violation of pretrial release conditions on domestic violence. In this matter, no bond has been set in this particular case. You are currently in case number 2020 MM1225. You had a battery domestic violence. You were out on bond on that case. Do we have anybody here?
Yes.
Okay. Ma'am, what is, hang on just a second. She's got a very loud machine.
Sorry.
That's okay, I know you need to use it. What is your name, ma'am?
Anna Cabral.
And what is your relationship, if any, to Mr. Leon?
We dated.
Past tense? Or still, I'm sorry?
Not together.
Okay. Are you involved in this domestic violence situation?
I'm the victim,
Okay.
yes.
Is there anything, one of the things I have to do today is decide what, if any, contact he's going to have, where he's going to live, and whether he should be released. So I need to know a little bit about any concerns you might have for your safety in this matter.
He's stalking me. He is watching me when I leave to the office. When I come back from the office, he knows what I wear and who I'm leaving with. He knows my residence. He just parks elsewhere in my parking lot. I just don't feel safe. I just need him to get help. His anger, and just everything. He physically hurt me. I have pictures. I have four different cases against him, and giving pictures to the officers. And I don't know what else to tell you. I just know that he has told me physically, and not verbally, also verbally, told me that he will slit my throat. And this is what I told the officer last night, because he did say that, and she did read it on a text that he sent me. If I did something against his will, that he will just, and it will be the state against him, not me against him.
State, do you have any input on this matter?
Yes, Your Honor. Takira Watson, on behalf of the state would argue that the defendant is not entitled to a bond. He was already on PTR where he picked up this new law and violated, and also given the circumstances, the state would argue that the defendant should not have a bond.
Defense, anything particular?
Your Honor, we would just ask that you set bonds in this case, and you can have a no contact order to safeguard the alleged victim in this case, Your Honor.
Well, his charge is a violation of a pretrial release condition that he have no contact, and that's the new charge in this case. He has, the former charge was a battery domestic violence. His past history shows some violent activities, including an escape. I think he is entitled to a bond, but the bond is not going to prevent him from having contact. I'm going to set the bond to $25,000. I'm going to require that he have no contact whatsoever with the victim. He is not to come within 1,000 feet of the victim. No contact means no telephone contact, no email contact, no contact through a third party. He is to maintain a separate residence. He's not to return to the scene where this happened. He is not to use any alcohol or illegal drugs. If he's taking any medication, he's to take those according to prescriptions. He may return, as I said, on one occasion with a law enforcement officer to get his belongings if he needs that. He's not to possess any firearms or weapons, and if he has any, they are to be surrendered. More importantly, on case number 2020 MM1225, this is the battery domestic violence. He is out on bond on that case. I am revoking the bond on that case, so he will not be getting out.
May I ask a question?
Yes, ma'am. Did you need to ask me something?
Yes, sir.
Yes, ma'am. Go ahead.
Okay, you said no contact. My office and his office is literally 1 block away from each other. So
Well, he is to have no contact, and he's to, what kind of work does he do?
He's a HVAC, heating and AC. And I work at a,
How far is your house from his?
maybe 20 minutes or so.
What
But
about
our
your-
offices are really close.
Tell me what really close means.
Our offices?
Yes.
Literally from about 2 blocks from each other. He can see where I park in my office.
All right, well, I'm gonna put a 1,000-foot limitation on him also. He's not to come within 1,000 feet of you at home or at work or anyplace else. Now, all this becomes moot because on his other case, I've revoked his bond. He's not going anyplace. Okay?
I don't get it, but okay.
On his domestic violence case, he had a bond that allowed him to get out, remember?
Okay.
She slept with me this whole fucking week. Cooked me dinner, slept with me in my bed.
Stop.
Why would you do this to me? I haven't done anything to you. Are you serious?
Sir,
I loved you,
no,
man.
ma'am, let him come back in, please. Let him come back in. I want him back in here, please.
All right, Your Honor, I would ask that we do not bring him back in here, please.
He asked me, he asked me to pay for his.
Ma'am, I need him back in here.
Sir, he asked me to pay for his attorney.
Ma'am,
Your Honor,
please.
my client is not in a mental state to be before.
Your
the
client knew
court.
exactly what he was doing when he was addressing the court.
He said 4,000 feet of his work.
Can I confirm my client for you, Your Honor?
You may.
All right.
Huh? Home, work, or residence or work. Okay.
May I please speak?
Ma'am, no. Sir, you burst out yelling at a witness, yelling in front of the court, disrupted the court in this matter with counsel present. I'm finding you to be in direct contempt of court. I'm sentencing you to 3 months in the Orange County Jail. I'm finding that you have interfered with the process of the court at this time and finding you in the contempt of court in this matter. You have a right to appeal, 30 days to appeal. If you wish to do so, the appeal must be in writing. An attorney can be appointed to represent you.
Your Honor, could we, in a state approach for a brief second?
You may. Hang on just a minute. If I turn this off, it's still recording, right?
If you,
I just don't want to blast
yes.
the recording. Not on direct contempt, on indirect contempt, he won't be. But it's a direct contempt when it's right in front of the court and I can see it. And I gave him the length of time I did because I think he's going to be in jail for that time anyway. Some law on it. All right. Yeah, I'm gonna have to do an order on it too. If you'll remind me, I need to take all that information with me so I can look it up. All right, ma'am, did you want to say something else? You do not have to.
He has been asked.
I don't want you to get comment on anything he has done or not done. Did you need to ask the court anything?
Ask you?
Yes, ma'am.
Or say what he's done?
No.
Okay.
You'll have plenty of time to do that.
okay.
But right now is not the time to do
Okay.
it. Okay?
Yes, sir.
All right, thank you. He's excused at this point. Yeah, I'll need to do a full written order on it, so maybe you can just give me a photocopy of it.
Do I leave?
Yes, ma'am, you're free to go. Thank you.
Thank you.
Okay, who do we have up here now? Is this Keith Parler?
Yes, sir.
Mr. Parler?
Yes, Your Honor.
I have 2 cases in front of me. It looks like I have 2 battery domestic violence counts. I have reviewed the charging affidavit. There is probable cause in this matter. I'm finding probable cause on both. I am going to set a bond on each one. The first one, I'm going to set a bond at $1,500. The second bond, I'm going to set a bond at $500. You also have a violation of probation in this matter. I'm going to set no bond on the violation of probation, which is under case number, I think it's 2019 CF 11348. Appoint the public defender to represent you on both of those cases. in these matters. You are to have, in the domestic violence case, to have no contact with the victim. You are to maintain a separate residence. You are not to return to the scene. You may return on one occasion with law enforcement to collect your belongings if you need to do that. You're not to consume any alcohol or illegal drugs. You are not to possess any firearms or weapons, and if you have any, they are to be surrendered at the time of your release. The public defender will represent you on both of these cases. Thank you, sir.
Good afternoon, Your Honor.
Okay, yeah. Just a minute, sir. Let me get there.
Certainly.
Too many pieces of paper in front of me. Let's see this out of here. And this is Keith Parlors.
Sorry.
So Ms. Leon is the one you wanted.
Okay, she never came on that one. I'm sorry, your name again, sir?
Mark Joel Anton, Your Honor.
Thank you. You have a failure, a defendant to appear. The judge has entered a order that you be arrested and held. He's got a no bond status in this matter, so bond will remain the same. Once you appear in front of the judge, he will go ahead and direct what it's involved with. I think it was a petty theft with 2 priors. You should be able to get that taken care of pretty easily, but you're going to have to appear in front of the judge who issued the order.
Oh, I understand, Your Honor. Thank
Okay.
you. I was going to say I have 41 days in on that.
Okay, well, your attorney will help you with that.
Okay, thank you.
Okay,
Have a good
thank you,
afternoon.
sir. Alvin Arroyo?
Yes, sir.
Mr. Arroyo, good afternoon. Tell me your full name.
Alvin Royal Jr.
Okay, the junior is the last part of your name, right? They've
Yes,
got it
sir.
as a middle name here for some reason. You have multiple counts in this case. You have burglary of a conveyance, possession of stolen counterfeit credit cards, petty theft, dealing in stolen property, receiving money from a pawnbroker. I've reviewed the charging affidavit. There is probable cause in the 2-page affidavit. I'm going to appoint the Office of Public Defender to represent you. I'm going to stay the bonds that are set. That's $3,500 on the burglary of a conveyance, $150 on the possession of stolen property or credit cards, $150 on the petty theft, $150 on the stolen, dealing in stolen property trafficking, and $150 on the receiving money from a pawnbroker in this matter. The public defender is appointed to represent you in this case. Thank you, sir. Darryl Aires? No?
Yes, sir.
Is that you? Okay. That's a little bit of an unusual name, or spelling, I guess, of the first name is what's unusual. You have a couple of matters before the court. You have a failure to appear on a felony warrant. The judge who issued that warrant set that at no bond, so bond remains at no bond until you get in front of that particular judge. You also have a possession of methamphetamine, possession of cocaine, possession of alprazolam, and possession of drug paraphernalia in case number 2020 CF 243. I'm going to set bonds in each of, there is probable cause, and I'm going to set bonds in each of those cases. In the first count of 1,000 on the methamphetamine, on the cocaine and the alprazolam, 150, and on the drug paraphernalia at 100. However, you were out on bond on a possession of a Schedule 5 controlled substance in case number 2020 MM 00060. You were on a bond of that, I believe, at $1,500. I'm going to revoke the bond in this case. You will be on a no bond status on that. The Office of Public Defender is appointed to represent you in this case. Thank you, ma'am. Benzita Belmonte?
Noah DeGilio, sir.
Bonded? Okay, Benzita bonded. Okay, thank you. Okay, I'm sorry, your name?
Noah DeGilio, sir.
Oh, do we have also a Daniels?
She's
Daniels
behavior, Your Honor.
behavior? Okay, that'll have to be recalled tomorrow. Sorry, finally got to you. Let me take a look here. Sir, you have a charge of possession of cannabis. It's over 20 grams. I've reviewed the charging affidavit. There is probable cause in this matter. I'm going to set the bond at $1,000 in this case, and appoint the Office of Public Defender. You also have another case that's presently pending of 2020 CT 000162. You do have a bond on that of $500. It was a cash bond that you filed. I normally revoke those bonds, especially when there's drugs involved. That involved more of an alcohol situation, as I understand it, than this, so I'm not going to revoke the bond at that point. You may still have it revoked. The state may file a motion to that effect, but the court's not going to do that at this point. Public defender is appointed. Oh, wait a minute. I have a notation that are you going to be hiring your own attorney, sir?
Yes, sir.
Okay. Let me tell you the scary part of that. You think you're going to be able to bond out or not?
I should be able to bond out, yes.
Okay, because if you're not, you're stuck in jail, you don't have the public defender, and you haven't hired an attorney, and that's really not a good thing.
Well, that's why I wanted to hire the public attorney just in case I wasn't able to make the phone call, you know what I mean?
Well, you can't hire him. I can appoint him.
Okay.
You think you're going to be able to hire your own attorney?
You think you could appoint him to me and just in case?
Well, you don't qualify financially. That's the problem.
Okay.
$500 a week.
Does he shine by $9.23?
Yeah, I will. I do. I'll appoint the public defender. I'm just concerned when you're downstairs and don't have anybody representing you. But if you're going to hire your attorney, make sure you get to him or her early so they can get prepared. And it also takes some of the work away from the gentleman next to you. Mr. Thompson's got his hands full as it is, but he'll be representing you, or somebody in his office will. Okay? Thank you, sir. Good luck to you. Ashley Delwater?
Yes.
Is that correct, ma'am?
Yes.
Okay. You have a charge of possession of cannabis and possession of drug paraphernalia. I've reviewed the charging affidavit. There is probable cause. Public defender is appointed. $1,000 bond on the possession of cannabis, $150 bond on the possession of drug paraphernalia, ma'am. Thank you.
Thanks.
Eric Gonzalez.
Sir.
Gonzalez here, I guess. Oh, yeah, I do. There's the water. There he is. Sir, tell me your full name.
Eric Gonzalez, Nicholas Gonzalez.
All right. I have two matters before the court. I have a charge of grand theft third degree, case number 2020 CF 2440, and a possession of cannabis of less than 20 grams, case number 2020 MM 1463. And in that case, in both cases, I found probable cause. In the misdemeanor case, possession of cannabis of less than 20, I'm going to release you ROR on that case. On the grand theft third degree, I'm going to set a bond at $2,500 in this matter.
Your Honor, I do see that he does qualify for pretrial release. And he has no history whatsoever. This appears to be a first offense.
He does not. He does qualify?
Yes, it is.
All right. We'll try you on pretrial release. Okay. Hopefully, we won't see you again.
On both cases, Judge, or just the one?
No, the one I'm going to just ROR him.
Okay.
He'll talk to you downstairs about pretrial release.
All right. Taiwan Keith Hollis.
How you doing, Your Honor?
Good, sir. How are you?
I'm fine.
How do you pronounce your first name?
Taiwan.
Taiwan?
Yes, sir.
So I had two chances and I got it wrong. I'm sorry. I'm notorious for that.
I'm used to that all my life in school.
I can understand. You have 3 counts: resisting a merchant, resisting an officer without violence, and scheme to defraud in this matter. I've reviewed the charging affidavit. There is probable cause. I'm going to appoint the Office of Public Defender to represent you in this matter. The bonds on the sheet are $200 on count 1, resisting a merchant. I'm going to stay that at that amount. Resisting an officer with violence, $200. I'm going to stay that at that. The scheme to defraud is listed as $4,000. I'm going to reduce that to a $2,000 bond in this particular matter. Thank you, sir.
Thank you.
Armand Pierre. Somehow I missed this one. This sounds really familiar. Oh, I know why. I had the warrant last night. Okay. I'm sorry. Tell me your name, sir.
Armand Pierre.
Armand Pierre. Okay, thank you. You have a arrest affidavit You have multiple charges on those. I'm going to go through this in just a minute. I saw that there were, reviewed the warrant in detail, and there is probable cause. As to the possession of ammunition by a convicted felon, I'm going to set the bond at $5,000. As to the possession of oxycodone, I'm going to set the bond at $150. Possession of cannabis of more than 20 grams, $150. Possession of cocaine, $150. Possession of a controlled substance, $100. Possession of drug paraphernalia, $100. Possession of cocaine of $150. Possession of cocaine with intent to deliver, I'm going to reduce to $10,000 from $15,000. Possession of cannabis with intent to deliver at $150, and the possession of alprazolam at $150. I'm appointing the Office of Public Defender to represent you in this matter. Thank you, sir. Nancy Ann Roten.
She's behavior, Your Honor.
Behavior, so I guess that's tomorrow, I'll recall. Terence Smith.
Yes, sir.
Okay. Mr. Smith, I have a aggravated battery, false imprisonment, and criminal mischief. I've reviewed the charging affidavit. This was an arrest warrant. I believe the judge has set the bond at, for count 2 and count 3 at $500 and $500. I'll stay those two amounts. As to the aggravated battery, my review of the affidavit causes me some concern. I'm going to set the bond at $15,000 in that. I'm going to require that you have no contact with the victim whatsoever, and that you maintain a separate residence in this matter. No contact means no telephone contact, no email contact, no in-person contact, no sending a message through a third party. You understand?
Yes, sir.
Okay, thank you.
The order says for him not to return to the scene.
Okay, and not to return.
Yes.
Not to return to the scene. Okay, thank you, sir.
Yes, sir.
Public defender is appointed. Marcus Jeffrey Ware.
He's behavior, Your Honor.
Okay, he has 2 cases. Robert Leonard Williams.
Yes, sir.
Mr. Williams, you have a charge of uttering a forged check. I've reviewed the charging affidavit. There is probable cause. Public defender is appointed. Bond is set at $1,000 in this matter, sir.
Yes.
Okay. Miles Smith?
Yes.
Is that you, ma'am?
Yes, sir.
Joe, boy, I'm going to mess up your name royally.
Jodeci.
Let me try. Joe, maybe I shouldn't. Jodeci? Jodeci?
I'm sorry.
That's okay. Everybody laughs at me. Go ahead. How do you say it?
Jodeci.
I wasn't even close. Jodeci.
Yes, sir.
Kayla, I got.
Yeah.
Okay, Jodeci. Okay. It's an unusual name. It's a pretty name. It's unusual.
Thank you.
You have no valid driver's license and no motor vehicle registration charges. There is probable cause in this matter.
Can I be heard as to bond, Your Honor?
I'm sorry?
Can I be heard as to bond?
You may.
I will ask my ROR in this case. This appears to be first offense. She has 0 criminal history and in-state or out-of-state. And she's 27 years old, no criminal history. I feel that's pretty good. In downtown, with no valid driver license, no motor vehicle registration, if our office helps her to obtain her driver license, these charges will probably end up getting no prost, Your Honor. But that's just for the court's consideration.
So you want to release just ROR?
Yes, Your Honor.
State, do you have any objection? What Mr. Thompson seems to tell me seems to be borne out by the report I have.
Yes, Your Honor, the state has no objection.
And I can't penalize her for laughing at me when I mispronounced her name, right? Everybody does that. I'm going to go ahead and release her ROR and appoint the Office of Public Defender. Thank you, ma'am.
Thank you, sir.
Did she have 2 cases? No, just the one. All right, James Christ? No? Do we have a James Christ? Are you Michelle?
Yes.
Okay, hang on a minute. Let me find out what's going on here. James Alfred Christ, is he here? Did he bond out?
Yeah, he wasn't on our list.
Where is it here?
When you see where,
One agency number?
no, see where you got the name highlight right here, 2000.
2005-266. Bonded, okay, thank you. For some reason or other, you just didn't look like a James, so I wondered. All right, and your name is Michelle Lynn Gill, is that right?
Yes.
All right, this is a trespass on property after warning in this matter. There is probable cause in this case.
They are offered to resolve the case, say?
State?
The state would be offering AG credit time served, no return to scene, and any court costs associated with the case.
I'll do that.
Yes.
I will accept that offer and enter a plea of no contest, Your Honor.
Okay, if you want to go ahead and fill out a form. It looks like she has some prior history, but it's not major, it's primarily trespasses. Thank you. Appreciate it. Ma'am, do you understand the charge that was in this matter?
Yes.
And you understand that your attorney has talked about resolving this matter today with your taking a plea?
Yes.
Is that what you want to do?
Yes.
Are you able to read and write in English?
Yes.
Let me have you raise your right hand so we can swear you in if I can.
Do you swear for any testimony shall give me the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Have you read over this plea form and gone over this plea form with your attorney?
Yes.
Okay. You understand that the charge that you have in this matter, if you decided not to enter a plea, you would have certain rights that you're giving up by entering this plea. Do you understand that?
Yes.
Okay, I'm going to go over those with you anyway, just to be sure. If you did not enter this plea, you would have a right to go to trial. You'd have an attorney to represent you in that matter. You could call witnesses, hear what the state's witnesses were going to say. You could cross-examine those witnesses and to see what they were going to say. You could not say anything and make the state prove this case, and they'd have to prove it beyond and to the exclusion of a reasonable doubt. Or you could testify at trial if you wanted to. Nobody could force you to, but if you wanted to, you could.
Okay.
You would also have a right to appeal. You would have a right to assert defenses. You could appeal anything that you needed to. If you give up, enter this plea, you give up all of these rights, including your right to appeal, except for the jurisdiction of this court and the legality of the sentence.
So I don't have a right to appeal in 30 days if...
You would not on anything except for the jurisdiction of this court and the legality of the sentence. And that's why it's important that you understand what the plea is. You're entering a no contest saying you're not admitting to it, but you're not contesting it either. And so essentially you give up all of these rights by doing that. You don't have to do that now. I mean, I'm going to set a bond in this matter anyway, if you want one, and you can think about it and do it at a later point if you want to enter a plea. It's up to you. If you're not sure, don't do it.
What would the bond be?
The bond is probably going to be $150.
Okay,
Talk with your attorney. Don't talk with me about it. I mean, I'd love to talk to you, but that's really not appropriate.
What do you want to do? You want to take the bond, or you want to fight it downtown, or you want to?
take the plea, please.
You want to take the plea?
Yes, please.
Okay. So you understand you're giving up all of those rights that we talked about? You sound confused.
Yes, I'm just confused as to,
In other words, what happens if you take the plea? I'm going to adjudicate you, okay? And I'm going to order you, how much credit she have, time for service she have?
2 days.
I'm going to order you spend 2 days in jail and give you credit for 2 days.
okay,
And I'm going to require you to pay some court costs, which we're going to tell you about. And other than that, that's what would happen. But if we do that today, and tomorrow you're released, and the next day you decided, I shouldn't have entered that plea, it's too late at that point.
okay, so, I'll just plead no contest.
Okay? That's what you would be doing as part of the plea. Is that what you want to do? Counsel, you might need to talk to her for a minute, because I can't.
I believe that she wants to take a plea. I think I've pled her out before, I believe. So,
Okay.
so we done this before.
Okay. You understand what you're doing is you're giving up your right to trial by entering this plea.
Okay,
You don't have to do it. You can simply go forward. I'll set the bond. You can post the bond. You can be out.
okay,
Or you can go ahead and enter this plea today. And the
I'll
case
take
is
the
over.
plea.
Take the plea. All right. You've signed a form. We talked about it a minute ago. Is this your signature on the form?
Yes, actually, I would like to re-sign it, please.
Re-sign it?
Yeah, I would like to sign it under my other signature.
You have more than one signature?
Yes.
Okay. I have one signature and I can't read mine, so hopefully yours are better than mine. Is it a different name that you use?
Yes.
You have to go by the name that's on the Michelle Gale.
Yeah. Just go ahead and let her
Go
sign
ahead,
it.
let her sign, or Michelle Lynn Gale, okay. Let her sign.
Told you this has been a weird day. I don't think I've ever been here this late.
There you go. Thank you.
Ma'am, what is your legal name?
On my driver's license, it is Michelle Gill.
Okay, but what is your legal name?
It should be.
The name your parents gave you?
Oh, Michelle Foyer.
Okay. And what is the name you utilize most of the time?
I kind of like to use Michelle Foyer these days.
Okay. And have you signed this by both names?
Yes.
Okay. All right. Do you have any questions for me about anything contained on this form?
No.
Do you have any question about what you're doing today?
No.
All right. You using any particular medications today?
No, I actually have not had my medication today.
Are you thinking straight?
Yes.
Has anybody forced you, threatened you, or coerced you to enter this plea?
No.
Okay. Do you want me to accept this plea?
Yes.
All right. I'm going to go ahead and accept your plea. Find that you understand the nature and consequence of your plea, that you're not coerced or threatened. You did sound a little confused at some point, but you're convinced me that after thinking about it, you do want to take the plea. Your attorney has recommended that to you also, that it's free, voluntary, and of your own free will. There is a factual basis. The court has reviewed the affidavit. I'm going to go ahead and accept your plea. With that, I'm going to adjudicate, send you to 2 days in the Orange County Jail, give you credit for 2 days' time served, assess court costs, fees, and fines. $323? $323.
Okay.
They have to be paid at the rate of no less than $25 per month. The first payment would be 60 days after you're released.
Okay.
I also am going to make it a condition of this plea that you not return to this property anymore. You understand?
Okay, understood.
All right. Do you have any questions for me?
No.
State, anything additional?
Nothing further, Your Honor.
Defense, anything additional?
No, Your Honor.
Ma'am, you have 30 days to appeal the decision of the court. If you wish to do so, the appeal must be in writing. An attorney can be appointed to represent you. Good luck to you, ma'am.
Thank you. God
Thank
bless.
you.
God bless you.
Mario Hill. Mr. Hill, good morning.
Good morning.
You have a charge of trespass, an occupied structure, refusal to leave. I reviewed the charging affidavit. There is probable cause in this matter. I'm going to appoint the Office of Public Defender to represent you. The bond recommended here is $500. I'm going to make the bond $150 in this matter. Thank you, sir. Ernest Powell. Mr. Powell? Come on, folks. Mr. Powell, good morning. Good afternoon. Good afternoon. Shows you where I am. Thank you, sir.
How you doing, sir?
Good. Tell me your full name.
Ernest Joseph Powell?
Okay. Mr. Powell, it says transient. Do you not have a place where you're staying, sir?
No, sir.
This is a trespass on property after warning. I've reviewed the charging affidavit. There is probable cause in this matter. I've appointed the Office of Public Defender to represent you. Let me see if
Your Honor?
Hang on
I
just a
plead not
minute.
guilty.
Just a minute, sir. Let me look at something here that they've given me. You want to speak about the recommendation regarding the bond?
Yeah, we'll just ask for a bond of $100.
State? He's got no place to live. He's transient. I'm not sure you can even pay $100.
Yes, Your Honor. State has no objection.
All right, I'll set the bond at $100. Thank you, sir. Robert Ramos? Are you Mr. Ramos?
Yep.
Mr. Ramos, you have a matter before the court is petty theft, retail. I've reviewed the charging affidavit. There is probable cause in this matter. I'm going to set bond in the amount of $500. You also have case number 2020 MM145, 462, which is a drug paraphernalia and providing false information to a law enforcement officer. That was a bond that was also set. I'm going to revoke bond in that case. In this matter, I am going to appoint the public defender to represent you in this matter. There you go. Don't forget to take something back with you so I can do that order on that other case.
Yes.
Okay. Lance Robinson?
Yes, sir.
Mr. Robinson, you have resisting an officer, obstruction without violence in this matter. I've reviewed the charging affidavit. There is probable cause in that. I'm going to set the bond at $500 in that case, appoint the Office of Public Defender. You also are an ROR at the present time on the petty theft with 2 priors. Give me a moment.
Your Honor, the defense asked that you take no action in that case, since the new law violation is nonviolent, and it's my experience that typically a lot with these resistant officers without violence, it's a case of sometimes our clients aren't moving as fast as the police officer would like them to move. I would like to take that in, for the court to take that into consideration, Your Honor.
He does have, his prior history includes, and of course, the charge that he's got in the petty theft with 2 priors essentially could make that a felony. He has some prior history that's a bit concerning. They're not violent crimes. State, defense, no, State, do you have a position in this matter? Really, the question is whether to revoke his bond or revoke his ROR on the petty theft.
The state would argue that the bond should be, that the RR should be revoked, Your Honor. The defendant did pick up a new law, so the state would object.
Or in the alternative, Your Honor, I would ask that you just revoke and set another bond.
I can't set another bond because I don't know the facts about it. I mean, he's charged, it's a misdemeanor case. No, it's a felony case because of the 2 priors. So without knowing his prior history on that, he does have at least 8 misdemeanors and 2 prior felonies other than this. I think I'm going to have to revoke the ROR based on the history that I'm seeing in this matter. I am going to revoke it. Public defender is appointed.
It's not over yet.
Thadeous Terrell,
Here's mental health, Your Honor.
mental health. There you go.
Your Honor, I would waive his appearance. So since he's on mental health, we can just start getting him.
That's on Thadeous.
Yes.
Trespass after warning. I'm going to appoint the PD on it. I'll set a bond at, let me hold on, I'll look at something here. Oh, he has a pretty chronic history. I'm going to set the bond at $250 in that. He has a significant history. And appoint the public defender. Okay. So he does not have to come back and show that his appearance has been waived by his attorney. All right, Tony Whitefield or Whitfield?
He bonded, Your Honor.
Thank you. Stanley Desire?
Yes, sir.
Is that you, sir?
Yes.
All right, you have an out-of-county warrant in this matter. It looks like Lake County Sheriff's Office violation, grant theft more, no bond status, so it will remain at no bond. You also have a bond of, a surety bond on a battery domestic violence resisting an officer without violence. I think Mr. Mead represented you in that case, is that correct?
No, nobody represent me because they had to redo my.
They what?
They had to redo my case all over again because I was in jail for like 12-something days on a VOP, which was for Lake County. They had helped me.
No, this is the battery domestic violence I'm talking about.
Yeah, Victor is representing me.
Okay, that's what I was asking. All right, I'm going to revoke the bond on that case in this matter. He's got already a no bond status in.
But, Your Honor,
Yes.
I have a question. So, what's the whole point of them to give me a bond when they hold me in jail for 12 days?
You don't have a bond in this violation case.
When we held the VOP, we held the VOP, then they gave me a bond, and I posted my bond. They released me, and now Lake County violated my probation.
Everyone's separate. You can have 5 different cases, but have a bond in 4 of them and not in the one, and you're not going to be able to bond out. Until you get that case resolved in Lake County, they're probably not going to put a bond on this case. So you're going to need to get them resolved. So I'm revoking the bond in it. Giovanni Martinez.
Yes, sir.
Mr. Martinez, you have an out-of-county warrant in this matter. It looks like it is a no bond matter, so it will remain at no bond. And that's on the violation of probation. Okay. Thank you, sir.
Thank you.
Michael Newby, or Newby? Sir, you have out-of-county warrants. Judge has issued a warrant. Looks like it may have been Jacksonville.
Yes, sir.
He has, it's the strangest bonds I've ever seen in my life. He has set bonds on count 1, defrauding an innkeeper, it looks like, of $25,003. Count 2, committing fraud, a bond of $25,003. Count 3, criminal use of personal ID, a bond of $25,003. And count 4, criminal use of a personal ID, a bond of $250. So he has set a bond. They're unusual bonds, but he has set a bond in those. This court takes no action when he does that.
Okay.
Thank you, sir.
One quick question.
Yes, sir.
Before can I bond out from here, or I'll have to wait till they transport me?
I think, number one, I think you want them to transport you because otherwise you're going to get stuck here. You'd better be bonding out up there. But yeah.
I'm sorry. That last bond is the same. It's just it carried over to here. So you said 250?
Yeah, there was 250. Okay, it was 25030. Okay, again. You can bond out any place if you got a bond, but the problem is you're better to get it up to Lake County to get it resolved, or to Jacksonville, to Long County.
Okay.
Okay? Thank you. Jeffrey Cedric Bernard. Is that you, Mr. Bernard?
Yes.
All right, you have 2 cases before the court. One is a possession of synthoid cannabinoids. I went ahead and reviewed the charging affidavit. There is probable cause in this matter. It looks like bond was previously set at $1,000. Bond will remain at $1,000 in this matter. Public defender is appointed to represent you.
Your Honor, would you have any objection to RRs in this case? I see that he may have some arrests, but he has 0 convictions in state or out of state. And because of that, and the charges listed, he will probably more than likely qualify for some sort of pretrial diversion program downtown. And he's a veteran, so he'll probably get into vet court.
So you're asking for what?
An RR. The charges aren't violent?
No, they're not violent. I'm looking at his past history that I have.
He has 0 convictions.
He has what?
He has no convictions in state or out of state.
State, do you have a position on that? I am looking at the sheet. It shows he does have had other charges, but I don't see anything as a conviction on it.
Are we looking, the defendant is Jeffrey Bernard, correct?
Correct.
And you're saying he doesn't have any out-of-state convictions?
I am looking at a printout sheet. I don't have access to it on my computer.
He has arrests, but there's no convictions.
He have out-of-state convictions.
Yeah, he
Oh,
does have
okay.
out-of-state convictions.
His last conviction was 8/27/2019.
Do we know what that was for? I can't read it.
Yes, it was resisting arrest, simple possession. That was for the 8/27.
Okay. All right, I see it on there. I didn't realize that, because it doesn't talk about the normal type of charges. All right, I don't think I can do that.
Okay.
I'll leave it where it is. Thank you.
So the bond is 1,000 and how much, Your Honor?
Well, there's two different cases. That was the one case, the $1,000. He's also got an open container case. I'm going to set bond at $150 in that. That's case number 000290.
And what was the bond amount, Your Honor?
150. Okay. David Butterworth. I don't have an arrest affidavit in this case.
Yes, sir.
If you can. Okay, I have, it looks like the charge is aggravated battery causing great bodily harm in a domestic violence setting. I have the capias that was issued, but I don't have any charging affidavit. I'm not sure why this was pushed off till today. I don't know what was,
I have the,
or you refused to come, I guess.
it was, direct, I have the information sheet, I think behind.
State, do you have any charging affidavit on him?
For Mr. Butterworth?
Yes, for some reason, it's just not in my materials.
No, Your Honor, I do not have.
I have it right here.
Okay.
You need a copy? It was a probable cause to order, Judge.
I'm sorry.
It was a probable cause.
Well, it looks like you refused to come. It's on one spot. Give me just a second, if you would, Mr. Butterworth. I'm trying to look over something I didn't have available before.
I'm sorry.
It's a probable cause to support.
Yeah, I've had a chance to review the affidavit in this matter. There is probable cause in this matter. The bond has not been set because it was a domestic violence. We have not heard from the victim. Do we have any input from the victim?
No, Your Honor.
All right, I'm going to set bond at $2,500. I'm going to require that he have no contact whatsoever with the victim. He is to maintain a separate residence. He may return on one occasion to get his belongings if he needs to with law enforcement. He is not to return to the scene. He may not consume any alcoholic beverages or illegal drugs. If you're taking any prescribed medications, you must take them within the source of the prescription. You are to surrender any firearms at the time of your release, and you're not to possess or own any firearms in this matter. There is no victim here in this matter. The court might be inclined to set a higher bond, but without somebody here to tell me what's going on, and with the notation in there that she's not being cooperative, the court's not setting any higher bond than that. Public defender is appointed in this matter. Thank you, sir.
Thank you.
Okay. Tracie Koger?
Yes, sir.
Ms. Koger, you have a charge of violation of probation. The judge has set a no bond in this matter on the warrant, so it will remain at no bond. In this case, Office of Public Defender is appointed to represent you. Thank you, ma'am. Johnny Anton Roxanut?
Yes, sir.
Say your name for me.
Johnny Anton Roxanut.
Oxanut?
Oxanut, sir.
Oxanut. I would not have gotten that pronunciation out of that. Sorry. You have a couple of matters in front of the court, or few. You have possession of ammunition by a convicted felon. I have reviewed the charging affidavit in this matter. There is probable cause. I'm going to set the bond at $4,000. And that's in case number 2020 CF 2433. In case number 2020 MM 145H, you have a charge of resisting an officer without violence. Bond is set at $500. There is probable cause in that. And in case number 2018 CF 6601, this is a violation of probation. The judge who set the bond has set it on the violation of probation, has set bond at no bond, so it will remain at no bond in this matter. On the violation of probation, the public defender is appointed to represent you in all three cases.
I'm sorry, Your Honor, what were the two other bonds?
The $4,000 on the possession of ammunition by a convicted felon, $500 on the resisting without violence. And then the VOP, the judge has no bond on.
Oh, Your Honor, I believe he's already been, is represented by Leslie Sweet.
Well, it's an on view.
Oh, it's on view?
Yeah, his
Yeah.
VOP is an on view.
Oh,
It's an on view.
Okay.
Does Ms. Sweet know that you're here today?
Yeah, she was here this morning to see me, sir.
Oh, was she? Okay, but she didn't stay for the hearing?
No, she just got all my information because she already knew you wasn't gonna give me no bond on my VOP.
Okay, all right, thank you, sir. Jeffrey McGee, I'm sorry.
So you want to put on the on view, you have an attorney, or?
Yeah, he's already got his own attorney. Yeah. I'm sorry. Mr. McGee? McKeith?
McGee is right.
McGee, okay. Sir, you have a charge of disorderly conduct. I've reviewed the charging affidavit. Under the affidavit, there is probable cause in this matter. I'm going to set the bond at $100 in this case. Appoint the Office of Public Defender to represent you in this matter.
Your Honor, is there a offer to resolve the case?
Give me one moment, Your Honor.
Take your time. He is listed as transient.
The state would offer an adjudication of guilt, credit time served, and any court costs associated with the case.
What's the credit for time served? 2 days.
What does that mean, I'm done?
Yeah, you'll be done with this charge today if you want to take that plea.
What, guilty, time served? Is that what you said?
Well, we're gonna plead no contest.
Yeah, no contest, yeah, no contest. I didn't even know what I was doing was wrong.
Raise your right hand. Do you swear affirm the testimony shall give you the truth, the whole truth, and nothing but the truth?
Yes.
Okay, sir, put your hand down. Tell me your full name.
Jeffrey Howard McGee.
Are you able to read and write in English?
Yes.
You understand you have a charge of disorderly conduct?
Okay.
You understand that, sir?
As far as I wasn't being hurtful or harmful, I don't understand.
It's not my question. Do you understand that's what the charge is?
Yes, I understand.
Okay. Go ahead and do what your attorney wants you to do there.
Yeah.
All right, I want to go over some things with you to make sure you understand. I know you have some prior history. I have looked at that. Do you understand that if you did not resolve this case today, if you didn't enter a plea today, that you would have a right to have a trial in this case? You understand that?
Right.
You understand you're giving that right up?
Right.
You understand that you would be represented by an attorney at that trial if you wanted to be?
I'm happy with the no contest.
Okay, I just want to make sure, I need to go through these things with you to make sure you understand that if you went to trial, you could call witnesses, to testify. You could see the witnesses the state would call. You'd have a chance to cross-examine those witnesses. You understand all that?
Yes, sir.
And you understand that the state would, if they went to trial, would have to prove this case beyond and to the exclusion of a reasonable doubt. You understand that?
Yes, sir.
You understand nobody could force you to testify. They'd have to prove it without your testimony. You understand that?
That's fine.
Okay.
I'd rather just go home.
You understand that you'd be giving up your right to assert any defenses, and you're also giving up your right to appeal, except you can appeal the jurisdiction of this court and the legality of the sentence. Do you understand that?
Yeah.
Okay.
I think so, yeah.
Have you used any prescription medication, any alcohol, or any over-the-counter medication in the last 48 hours?
No.
Are you thinking straight today?
Yes.
You understand everything I'm saying?
Yes.
Ever understand everything your attorney has said to you?
Yes.
Anybody threaten you, force you, or coerce you to enter this plea?
No.
Okay. I have a plea form here that it looks like it has your signature on it. Is that your signature?
Yes.
Okay. Have you talked with your attorney about what's on this form and what you're doing today?
No. Just met him.
Okay. You want to go over this with him a little bit? This is what we're utilizing. Some of these things I've gone over with you, but you're welcome to take a minute and go over with them. You could give him this to do that, please. We do this so there's no later on, wish I hadn't have done that. That's what we want you to understand what's going on. So just go over that with your attorney very briefly.
This time served, I mean, there's no point in dragging this through the mud.
Hang on, just a minute.
So,
No, indirect, not two different things. There's one thing, indirect contempt. It's actually direct contempt.
Okay, so not,
Take out the word in.
oh, okay, so also direct contempt of court and civil offense of 3 months on transfer.
Right.
Okay.
Yeah, and I'll,
You say you still gonna have out of order?
yeah, this is a case number.
Yes.
I'll be here forever.
There you go.
Indirect. When a guy blows. All right. Did you get a chance to go over this with your attorney now?
Yes.
You think you understand what you're doing today?
I understand exactly what I'm doing, what I want to do.
Okay, and you want me to go ahead and accept the plea?
No contest.
Yes, you want me to accept it?
Yes.
Okay, I'm going to find that you understand the nature and consequence of your plea, that you're not coerced or threatened, that your plea is voluntary and of your own free will. There is a factual basis based on my review of the charging affidavit, and you're represented by competent counsel. I'm going to go ahead and accept your plea. I am going to adjudicate as to the one count, sentence you to 2 days in the Orange County Jail, give you credit for 2 days' time served, assess court costs, fees, and fines, $273. Do you have a job, sir? Do you have any income at all? I'm going to reduce that to a civil judgment in this matter.
Thank you, Your Honor.
You have 30 days to appeal the decision of the court. If you wish to do so, the appeal must be in writing. An attorney can be appointed to represent you. Good luck to you, sir.
Thank you.
Thank you. That's the weirdest day I've ever had out here.
See, you see your wife coming to read for you. And see, she don't come read for you no more.
Well, when she reads, that doesn't help me much, but I think the longest I've ever been, I think I've been here one time. Well, my first time I came, that was 18 years ago. But ever since then, I've been out here by 2 o'clock at the latest. Today was just a strange day. Juvenile was a mess. Yeah, and then this stuff, yeah. This was just weird stuff. Okay. That's yours. This I gotta remember to do. Yeah, it is yours. Yeah. I'm trying to look at what am I doing here. You just don't want me to throw these things out?
This is,
Are you one of those paper herders?
They have to shred it, because they got the information stuff on it.
Madam Clerk. Okay. Good job. All right.
Thank you.
We got, yes, we're done. We're done.